Hmm. Why? Whose? I've heard him. That is that matter, no? I've asked you to file a. Yes. No adjournment. Matter has been heard by him. I'm doing one about. How is he possible to file a? You've got the records? And I had also asked for another thing. As regards what was the value of the land?
Accurate, but that cannot be seen for the, but I received it at about 4:30 in the afternoon yesterday.
Hmm.
That is missing.
Why? Ale,
section of ever then section of this is all of time. Charita item and one. Charita item 9. Charita item 9. 1 to 1780. Have to cover misplaces. 1 to 17 ago. All of my lord.
why? You're going to spiritual?
মই চেক কৰিব লাগিব মানে
Hmm?
যিয়ে মিলাইছে কালি ৰাতি তাক যিয়ে ৰাতি চেক কৰিছে পঠোৱাৰ আগত তেওঁক মই ইনকুৱাৰী কৰিছো
The order do you want to? I don't have the file.
মই 1 মিনিটত 5 মিনিট সময় দিলো সেকশনত এবাৰ দিছো
And from this, I couldn't find out the notice for fixing when the date was fixed. Because there is only one document which is being seen out here. That was a document. It's a handwritten one of the. It is done. This is the only document which is there. No query. Whereby a date has been fixed. So whether that was at all, this is handwritten. This couldn't have been published. There only the date was fixed as in the month of May. Next page. Yes. This is the only document which shows that there is some notice.
There's another one, right?
There is no other. All the other document shows, and more particularly, there is a document issued by some subdivisional officers stating that the date also needs to be mentioned in the gazetted notification. Because your gazetted notification says after 1 month.
This 8/5/2007 was a fine claim in the report. In Paraguay's comments, which was filed by SQ, Romia, says that পট্টাৰ জমি নিলামৰ নটিছসমূহ পট্টাদাৰৰ ওপৰত জাৰি কৰাৰ জৰিয়তে 10/11/2006 তাৰিখে
And that is 10/11/2016.
উক্ত জাননীৰ জাৰি হোৱা প্ৰতিবেদন ইয়াৰ লগত ৰাখি দিয়া হ'ল। জাননীত উল্লেখ থকা নিৰ্ধাৰিত 22/12/2006 ইংৰাজী তাৰিখ কোনো এজন পট্টাদাৰ আদি উপস্থিত দেখা নাযায়। আবেদনকাৰী নিৰ্ধাৰিত সময়ৰ ভিতৰত অনদায়ক খাজনা আদায় দিয়াৰ দূৰৰ কথা তেওঁ কোনো আবেদনেই দাখিল নকৰিলে। এই প্ৰমাণ কৰে যে তেওঁ ইচ্ছাকৃতভাৱে খাজনা আদায় দিয়াৰ পৰা বিৰত আছিল। তাৰ পিছত বিধিমতে চৰকাৰী ছপাশালৰ জৰিয়তে 23/3/2007 ইংৰাজী তাৰিখে অধিসূচনা প্ৰকাশ কৰা হয়। জাননী আৰু অধিসূচনাৰ কপি সংলগ্ন কৰি দিয়া হয়। তাৰ পিছত দ্বিতীয় পৰ্যায়ৰ উক্ত পট্টাৰ জমি নিলামদাৰ দিয়াৰ 4/5/2007 ইংৰাজী তাৰিখে ধাৰ্য কৰি চক্ৰ বিষয়ে সমগ্ৰ চক্ৰ কাৰ্যালয়ত মুকলি ডাক দিয়া হয়। উক্ত ডাকত দুইজন ব্যক্তিৰ মাজত ডাক হোৱাত
Because one quoted 2,20,000, the other quoted 2,80,000 for 280 acres of land. One is a question. He had to pay 36,000. Once you realize this 36,000, the remaining amount goes to him. Yes.
indeed,
So he has a right that if it is sold, it is done at the highest price. So the notice which has to be widely circulated. That is his loss. Apart from other things which we have done, that is a different thing. As to how you could have sold 280 bighas of land in 2010 or 7 or 8, 7 at 1,000 rupees per bigha. And the exact land will be somewhere near before Bahatasari.
right.
The prime land. And at that point of time, the four laning had already started. So unless and until there is some involvement of your officers in hand in glove with anybody else, this couldn't have happened. It is unthinkable how a person would quote 2,20,000 for 280 bighas of land. And the second one quotes, which is the petitioner herein, at 2,80,000. If that be so, what is wrong with the Board of Revenue's order? And this court will be exercising a jurisdiction for writ of a certiorari. Why should this court at all exercise? Challenging when that order is challenged, and this court doesn't find anything wrong with that. But the only reason why I'm keeping the matter, otherwise I would have passed the judgment now. Only reason why I passed keeping so that we can catch hold of those persons who were involved apart from the petitioners in doing all these things. Because the circle officer or the SDO or the deputy commissioner, Kamruk, cannot shy away from the fact that what they have done. The government is trying everywhere to get lands out there for making acquisition of lands everywhere. And here, under the nose of the government, this land is being sold at 1,000 rupees. A very serious thing. Couldn't the government take it on its own at a price more than that? I think 10 times that price, the government would be happy to take it. If they get that thing at 28 lakhs, 280 bighas of land, the government will be happy to take it. Even at 28 lakhs.
The land, the sizes of the land, the lakhs of rupees as a scholarship.
Even a lakh, forget about other things. 202.8 crores would have been, the government would be happy to take it. Forget about the other. Getting it, and 2.8 crores also the government would be happy to take.
These are the records that this land
No, we want the valuation. Because that valuation will clearly show what was the valuation at that point of time. And when my order was very specific and clear, I made it very clear to the effect. Further directed, if the records of so and so is lying in the custody, you must have got it from the Assam Board of Revenue.
No, but these have come to the deputy commissioner.
Because this court had directed the deputy commissioner to send the records and to also trace it out from the Assam Board of Revenue.
The record in original is in this institution. The record in original is in this institution.
That's very good. shall hand over the records so and so. Then shall produce, will know which in turn shall produce. You get the revenue rates. You get the revenue rates. I'll fix it on 28 at the top of the list. And Mr. Counsel, if your senior is not well, this court doesn't adjourn on the ground of the senior. I make it very clear. So under such circumstances, you and seniors, you can engage somebody else. There's nothing else. It is only the advocate on record having any difficulties this court sometimes considers. But this is a matter where this court is not going to consider, taking into account that the matter has been pending since 2011. Ms. S. Sharma, the learned counsel appearing on behalf of the Deputy Commissioner, Kamrup Rural, had today produced the records pertaining to auction sale case number 2/2006-7, pursuant to the order dated 12/9/2023, passed by this court. From the said records, this court could not find as to when the notice, how the notice, as to whether any notice was published pursuant to the Gazette notification, thereby fixing a specific date for the auction sale. The records, however, indicate there's a handwritten notice issued by, a handwritten notice of, who is it? Immediately after that, Gazette notification. Give it to me. The records, however, indicate that there is a handwritten notice issued by, dated, handwritten notice dated 13/4/2007, issued by, who is this? Mohokuma? issued by the SDO, thereby fixing the date of auction on 4/5/2007. SDO Nogam and Rungya. It is not known as to whether the said notice was duly published. This court further taking into account that an area of 200 and an area approximately 280 bighas of land was auction sale at rupees 1,000 per bigha in favor of the petitioner, which was set aside and quashed by the learned Assam Board of Revenue. In its judgment and order dated 23/12/2010, fixes, directs the Deputy Commissioner, Kamrup Rural, to file an affidavit bringing on record the revenue rates as the rates fixed by the office of the Deputy Commissioner for such plots of land by the state government, oblique the office of the Deputy Commissioner for such plots of land, as well as the then existing market value of such lands. The said affidavit be filed by 26th of September 2023. The records so produced by Ms. S. Sharma is returned with a direction to produce the same on the next date. This the matter again for further consideration on 28/9/2023 at the top of the list. The registry shall serve a copy of this order to Ms. S. Sharma for due compliance. But Mr. Counsel, making it very clear, next time, otherwise today was the case, I would have disposed it.
Supplementary list, I don't know, 20 some of the list for hearing.
Yes, Mr. Chaudhary. I read it on the last occasion. You have the permission only for ground +1. You constructed ground, mezzanine, N1.
Now, this land was purchased with discipline interest in 1997. They had constructed the house in 1997. They had constructed the three-story house in 1997.
Who? You?
My parent, this is father's location. And it was assessed in my year 1997. In 1997, my lord, the notice for assessment was given, and assessment was given, my lord, on 3 occasions in 2007, 2008, and also 2010. So all these minor documents will show that might of the houses, I refer to the documents, the house was there in 1987. Assessments were being, taxes are being paid, taxes are being paid in the next 3 months. Now that they are proceeding on the presumption that there was a NOC obtained in 2000, and this construction is in violation of the permission in 2000. In case of the that in 2000 they did not have any occasion to mind of the ask for NOC for construction because the house is already there since 1997. And therefore there was
No, in 1997, it is in the GMC area.
yes, ma'am. Yes.
So in 1997, how did you construct it without a permission?
Might of the these were might of the constructed by the parents and
Parents or whoever it is would not absolve you to construct without a permission. Assessment, Mr. Chaudhary, could not help you.
when the taxes and the many times taxes are being might not collected not only one point of assessment being made, and there is a clear might of indication in the assessment also itself that the house is constructed in 1997. And the permission which both the might of fathers of the petitioner have tried. So they have.
Where is your assessment done? Assessment order?
And also with find that this side of the.
Page 33. Where is the assessment done? No, this is an extract of that. This is an extract of the assessment register. Where is the assessment order? Because in the assessment order, there is a stamp always, which is states that this does merely assessment doing assessment would not legalize any illegal construction. Huh? Yeah, there. The assessment does not any violation. Yes. And that is always there. This was done because at one point of time when matters used to be there in that court before Justice Jain Sharma, he had taken that without putting that notice out. So there were some orders being passed, but thereafter they have put this. So
Other question here is, the records are with them, my lord, and there was direction to produce the record.
records for what?
Record my lord, regarding this permission, they were.
Did you take the permission? I'm asking you, did you take the permission for construction? The burden lies upon you.
My lord, this is a piece of my 1997 construction, and my lord, the petitioners, others will be my lord persons who have obtained the construction and made the assessment and they are staying there, because they have inherited this property. They don't have those documents now.
So, can't help it. Yeah, can you ask them to trace out something which is not there?
No, my lord, law should see only the order pass. They must be with any company order.
Yes.
That order is fine.
Hmm.
Whereas I, Dr. and Okamoto, I, Chief Executive Officer, GMBA, asked this order as per our comfort to this authority under section 88 of the GMBA for removal of unauthorized construction and the use of RCC building constructed in violation of the permission accorded from this authority by the NOC 14/11/2000. Our case is that we have not taken any NOC and nor neither we have made any construction after 2000. whereas super code was issued to use to return of a substance in the name of super doctor.
But are you saying that this document is the document which have been enclosed at page 11 does not belong to you? Huh? Apurva Kumar Datta.
Please same your worship will can see. No, this document, madam, they say this is the permission to your current madam. We say, madam, we do not know of any permission.
No, is this the document belongs to you?
No, this has been madam connected in. No,
Who are you? What is your name? Sofal Datta.
no, in fact, madam.
Daughter of Apurva Kumar Datta and Manas Deya, late Arun Kumar Dao. This is it. So this is in respect to this particular document, and this is on the basis of some application, 7/8/2000.
That is what we have shown.
So you have not issued this notice.
We have not asked for any permission.
And were these people alive, Apurva Kumar Datta, Arun Kumar Das at that point of time? So they were alive at that point of time. And this property you did not inherit at that point of time.
So we had at that point of.
When did these people die?
The mother of one father expired on 12/15/2006, and the father of the expired on 1/5/2009.
1/5/2009. So at that point of time, these two persons were there. So are you saying that you have no knowledge that this application was filed? So this is the only document of which shows that there was a permission which has been given only to the ground in the first floor. This is the only permission which was granted. In respect to, is this the DAG number? We are concerned. DAG number 914 new 1754 old, Patta number 540842. Yes. DAG number 1. Yes, that is the DAG, which is shown as the year. So this was given to your parents. Then how can you deny it? So, and this is only a plot of land measuring how much? 6.24 less. The total land is how much? Huh? 15 lessers, SS land, 15 lessers only. So this is the 15 lessers, and the year of construction has been shown as 1997. And this permission was taken subsequently.
No, my lord. That document was because everything was initially on the basis of some complaint.
But be that as it may, earlier permission is not there. Isn't it required to have a permission after the 1971 Act? Or even the 1985 Act?
Permission must have been there, my lord.
Can now, if you can't show it, how can you say that they are wrong?
After so many years, after making the assessment,
So
assess not only once.
the assessment does not confer you the right as regards any violation. Or if you have made any construction in violation of the assessment would not give you any rights.
But assessment indicates what is the area of complicated construction.
Assessment is only for the collection of tax.
But it indicates what is.
But it does not remove any illegalities to the building.
What is illegality? You want to establish an illegality, my lord. There has to be shown that this was constructed proceed in violation of some law.
Yes, that is what they are saying now.
Why it's no matter. They say that in 2000, you have taken permission and this is in violation.
Hmm.
And my lord, they rely on a document which are also come to this 9. There was an inquiry report. And on the inquiry report, my lord, what they are saying that is came. Is my lord, this is not to Nirmal Kumar Sen, not the petitioner. This is the inquiry matter they have made.
To me, your salary,
This is what my lord.
Case number 71. Number for telling the person, you can order this and go to. Very fast, correct?
this was between Nirmal Kumar Sen with these two persons.
This is in 19.
You see it here, where the vendor is the absolute owner and title holder of a total area of land measuring 1 katha, out of which a portion of a part of land hereby sold is 15 lecha with RCC construction under holding number 64, ward number 18 of so and so. So this was the land. It had an RCC construction.
Page number 30 to make it clear.
And here, if you see this RCC construction which was there, which is there from the assessment of Nirmal Kumar Sen in respect to the land, which shows that the RCC 2-story building, first floor having been assessed as holding number 127, and Assam type was a godown in 1978. That's all. It's a 2-story building.
So, Madam, what is the actual page number 30?
Page number 10,
30.
30.
The schedule of the.
Yeah. Holding number 64. No, that is what I'm saying. Holding number 64, kindly come to page number 10 of your affidavit. Ground floor, residence and commercial use, 80, Assam type house, commercial use.
There's an assessment of these things, I know that is an assessment of in 1996.
No, that is certified to be true in 1996. Not assessment made on here. This is certified only on 19. This was done earlier. This has to be prior to that. Because the sale did happen when? 89.
7th July.
If it is in 89, how can you have a 64 holding if it was assessed in 1996? This is a certified copy which is being given. This assessment was done somewhere in, there will be a date somewhere mentioned.
There is a date, my commissioner, there is 23rd, sir. 23/7/19.
Year of construction 78, 79, out of which 50 meters of Iman is so and so. Year of construction is Iman, self Iman, ground CC so and so, go down so and so. This was done under that 1969 Act. So must have been done before 71. That is why in 1989 this was the year. Anyways, and this is the permission which your father must have taken thereafter to make reconstruction or whatever it may be. The Assam type house which was on the top, you wanted to change it. Anyway, Mr. Bora, you see, the bylaws at that relevant point of time, more particularly bylaw number 18, stipulate that you should not demolish unless it is now, whatever may be, can this, is it not compoundable?
Turn to the page number 11 of my.
Huh?
Page number 11 of the NOC. NOC is absolutely clear, residential.
Yes, what they have done?
They had started with commercial, industry and commercial.
G plus 3.
Started to repetition, page number, assessment, page number 35.
No, that this authority sought clarification from the Guwahati municipal on what basis the order was passed in the assessment sheet showing the year of construction of G plus 2 as on demand. In response, the associate planner of the office reported that the use deviation as alleged is found as ground floor is being used as godown and the mezzanine floor is used as manufacturing unit of umbrella. Further, it was reported on examination of the initial assessment sheet of demand of Mr. A.K. Datta, it is found that during 1897, these structures were already existing. RCC plus semi-RCC, first floor with so-and-so, Assam type house. Later on, another assessment was done in the year 2007. It is found as a ground floor, mezzanine floor, first floor. The above from the Iman. Where is that property? Satrivari. But the initial assessment was done for commercial purpose. 64. Residence and commercial purpose.
At that time, there is no NOC. Then only 2000, NOC in 2000, 14, 11, 2000. Only for residents. Only for it. Page number 11 of my affidavit. Down below that.
Second floor is not allowed due to far restricted. It was only given for ground floor and first floor. Where does the mezzanine floor come into?
FAR has to be not only presently, but when existed. At the time, the FAR must have been different.
But at the time when the building was purchased by you, it did not have a mezzanine floor. That is clear for me, Asili.
Was it not necessary for the application that has been signed out in the NOC in 2000? So that my lord, it can be ascertained that whether they did not have applied for the NOC in 2000.
Are you disputing this?
That is 2000.
You are disputing. So if you are disputing it, means we are to take it that this, you are not basing your right on the basis of this document. And have you filed a reply to this stating that it is a manufactured document? But one thing is there, you have no permission prior to 1997. No. If you can't show, the burden is on you. For that, your burden is on. If you can't show, that is your lookout. Now, then why should this court at all exercise a writ in the nature of sorcery? If you could have the same deed, why not that? Because the sale deed, which was made in the year 1989, categorically mentions only ground plus floor. Ground plus and first floor, it's a two-story building. Yes.
Second paragraph will say,
Again, letter was issued by number 4/2013 in the name of requesting to furnish a copy of any order of the appropriate authority for transferring the land and building in your names and the receipt on which the same has been transferred at all in your names. You have received the letter on 4/2013 and the reply.
Mr. Chaudhary, those are not necessary. The only question is the violation. Kindly, no, Mr. Chaudhary, kindly come down. Kindly come to page 53. The above from the Iman was confusing and the Guwahati Municipal Council for clarification within a specified time. This authority after close examination is of the opinion that existing G+2 is constructed and used in gross violation of the NOC dated so and so for a G+1 building, whereas the second floor was not allowed due to restrictions on allowable farm so and so to demolish the unauthorized portion of the so and so building.
But it's a presumption. You have presumed why.
If you don't show it, they will obviously presume.
Why does this order saying that paragraph 3 that I have not given a reply? My reply has not been considered. That is at page 51, whether they have received it.
Page?
It's 51.
Yes.
There is a seal of it, my lord. This is the reply given to the notice, which was given on 4/2013, and 14/3 is the reply. And the implement order is, my lord, 15th of November 2013. This has also not been considered. The same was the reply. We asked for time because, my lord, the NOC and everything, my lord, documents it needs to be collected from GMC. GMC was doing everything at that point.
Understood, but this has gone for the last 10 years. Have you got it? As of now? Or is it because of the stay order you are not reluctant? We vacate the stay, then I think some urgency will be there on your part. You have not been able to produce anything. As of now, you don't have anything. The sale which was made to you was only ground plus one. And thereupon, this was the permission which was granted. You deny. Let us see what you have denied. You say that there was no permission applied. Let's see.
Yes, do you see that?
Where is it? The order dated Iman is being on a misguided in assumption implying petition never concealed the fact of the as the petitioner never had any knowledge of the existence of any documents. You are saying at paragraph number 5 that you have no knowledge. You have not stated that you deny. You don't deny the existence of that permission. You do not deny that your ancestors have applied for that permission. Where is it?
Yes, but we say that we have no knowledge. Therefore, they will show that the application.
No, there is a permission which is only for ground plus one. Then that is the only consequence one will draw. You say that you have no knowledge. You have not denied that there was no permission taken. Were you minors at that point of time?
We say, madam,
In 2000. What was your age? Let's see.
where was that, madam? Original pertaining to MSc
You are 42. 42 in 13 means 30. You are 30 years old.
Now, that's the freedom. We do not have to be dynasty. The only documents we have are the assessment order at a very point of time. And therefore, my lord, perhaps your worship, you have regarding the compounding. Otherwise,
No, but if it is, can it be compounded beyond the far? No. You have these bylaws, na? Compounding was given, na? Flexion bylaw. Where is the building bylaws now present? No, nothing comes. You have a new one, na? It will be the JMDA building or the JMC building bylaw. Where is it? We have the compounding will be done as per today's rule. Asani. 112. Not there? No, which book you are looking?
It's not there.
No, this is of 2012. How can you get the 14? 14 days, some book I've seen. Where if we see the building bylaws, says here, how much is the compounding, permissible compounding? It's there. There's a book, no? Yes, compoundable maximum 10% FAR. Non-compoundable use of building, addition of extra floor. Hmm? This is at the time of construction. Your book, this is your book of that is of 1998. This one has the building bylaws of the 1998. Thereafter, this is nothing. Huh? Taxes is okay. Did I ask for the taxes? No, I don't think so. No. I never said about the taxes. He must have heard there is another matter where during the meantime there were many matters which was taken up maybe. So he must have seen. Yes. Please. Is it prior to Priyanka Estates? Because Priyanka Estates division bench and then the Supreme Court, they finish all the rights. That was the judgment there. I was the lawyer out there in the Priyanka Estates matter here. So thereafter the matter went to the Supreme Court. The Supreme Court there, I engaged the advocate, Mr. Nabde. So that day I met him out there. He was telling me, help it. This is no. That is what I'm saying. This is after it. No? Priyanka Estates comes before. Because Priyanka Estates, it was the specific contention made that they have given us, they have legalized it by taking our assessment. The division bench, the same division bench. This is Sudarshan Reddy was the Chief Justice and Justice B.P. Gotoki. They have decided that. And this has been further approved by the Supreme Court in the other, whereby liberty was given to those other people who were enjoying out there and who were being sold for them to get the benefit, to claim, make claims again. Anyways. Now, what are the judgments, Mr. Chaudhary, you wanted to place? There is a judgment of Justice Jain Sharma. 3 years. 3 years. Hello. Mr. Bora, what best can be done here? Not as a lawyer of the JMC or the GMJ, but being proficient in the building bylaws. Tell me what best, how can the petitioners be helped to certain extent? Additional of floor is not comparable, I also know. This was 98. After that, it became more stricter. After that, Justice Biswas judgment. Yes, there you became more stricter. But that is another thing, but addition of floors.
A portion that is in the law, so in the other law, that will remove.
Now, what they have done, the assessment has been done as ground floor, mezzanine floor, and first floor. So you can't make it G plus 1 plus 2. But G plus GF plus MF plus first floor, can it be done? Hmm? Let us see one thing. 1997, this thing which was done. Let's see, it was done as 1997 three-story building. And what is this 64B? 64B is in whose name? Name Chhatrapati SS Arun Kumar Dove. But what was sold was 64. This is 308. This is Supali Datta. This is, I think this is after the death of the persons, no? Your predecessor's death. This must have happened. Page 35 is after the death. This is a recent one. Now, what is page 37? Page 37, assessment was done again under the 69 Act. Quarter 2007-8, third quarter. There you still have 64B. Ground floor, first floor, and mezzanine floor. That is 64B. And this has been assessed as commercial. So the use, no, if the use was all along the same, by way of permission, you can change it.
We were there in the commercial as well as prior to taking that, but that building was taken without any, for example. But go and not
64B, again done in the third quarter of 2010-11. When you carried out the election of RCC, but are you saying, because somebody must have filed an affidavit, no? Yes, 42. Mr. Manas Do. What does it say? That you don't know when the construction was made after the purchase in the year 1989? All the 3 floors? No. This is done recently. What is your statement? When was the construction made? Because you were then there. This purchase was made in 89. Filer registered after purchase, Zoya got his possession, be that as it means so and so mutated his name in 1997, passed by the joint commissioner in month. It is worth to mention here that the records available with the source that by notice dated so and so, the deputy commissioner had assessed the rateable value as per the ancestors were absolute owners of the land. The Apuna had purchased the RCC building jointly. Later on, they made order and divided the land into two parts, and each was enjoying his rights share in the RCC building to the exclusion of so and so. And after his share in the events, and accordingly, so and so got a refund. In the RCC building in 2008 and from CMC building and regularly paid the tax. Either they would be in the quoting assessment. So you have not said anything that when it was constructed, you only base your claim on the basis of that document. Huh? Making payment of taxes. Because only one thing. The person who has sworn the affidavit, he was 27 years old when the construction was made. He could have very well made a statement. The very clever type of drafting. I passed the order today. This will be dismissed. However, liberty will be given to the petitioner for the purpose of filing application for what you call for revision, for submitting, for what? For compounding. But compounding can't be done for one apply unless you submit a revised plan. You can't ask for compounding. You can't ask for compounding because it's addition here. So if I say for compounding, this court would be violating the bylaws. So this court can't direct for compounding. The petitioner would be at liberty within 1 month if they submit, and thereupon they will consider. That is the only way out. No, I'll dictate it. I'll come in 10 minutes and dictate it. Mr. Choret, I was thinking let us assume that you have made a construction illegal. If an illegal construction is done under 337 or under the GMDA Act, that can be demolished. But if you submit a plan, and if it is permissible under the bylaws, it's not for compounding, but for the purpose of revision, revised plan. On the basis of the bylaws, if it is permissible. What is wrong in submitting a revised plan? Just think about this. I'm coming. That is the basic. If question of compounding does not arise. Compounding will be things which will be, you can compound, means anything which is compoundable. But if it is not compoundable, but as per the building bylaws, it is permitted. But for the fact that he had not taken the permission then, it could not be. Can he not submit a revised plan for consideration? And thereupon you will be taking your decision. That is the only way out, Mr. Shubha. There is no way out. You don't have otherwise anything. If it is permissible. Therefore, I say, if you see the earlier bylaws, Rule 18, it says, because this was the, yes. Yes, violation penalty. Any person who contravenes any of the provisions of these bylaws or any requirement or obligation imposed on him by virtue of these bylaws, or who interferes with or obstructs any person in discharge of his duty shall be guilty of an offense which may be fined. That is okay. Nothing in these regulations shall require the removal, alteration, or amendment or prevent the continuance of use and occupancy in a lawfully safe of life and property. So, if the building permit, maybe it may not permit if it is beyond the FAR, because a FAR is being given. But if you use it as a FAR for commercial, because one has to take note of that it was all along commercial. The sale deed also says to be a commercial. The permission was taken residential, whatever it may be. But although it was already a constructed building, permission was taken. Now, once the permission has been taken, one cannot deny, they can't deny that permission which has been taken. Now, can they submit a revise so that it can comply with the present existing bylaws? And that is a question of fact which we will decide. Coming. Issued by the Chief Executive Officer, Guwahati Metropolitan Development Authority, whereby the petitioners herein were directed to demolish the unauthorized portion of the building and stop the unauthorized use of the same within 5 days from the receipt of the order, failing which the GMDA would be free to proceed with the demolition of the unauthorized portion of the building or sealing of the premises of the unauthorized construction and use of the building on its own without giving any further intimation, and expenses shall be recovered from the petitioners. The facts involved in the instant case, as could be seen from a perusal of the pleadings available on record, shows that one, Sri Nirmal Kumar Sen, by the registered deed bearing deed of sale bearing deed number 2459/1989, transferred a plot of land measuring 1 katha 10 letters under patta number 150, dag number 178, old 842 M 914 new M মানে M old to old দিব Indian M মানে M থাকিব 842 M dag number 914 N, situated at Krishnanagar, Paltan Bazar. Sold 1 katha 10 letters now, 15 letters already. Covered by patta number 150, covered by dag number 1758 old O 842 new M 914 N, included in patta number 1540, situated at Krishnanagar, Girija Das Colony, Paltan Bazar, Guwahati, under Moza, Sohar Guwahati, Block 2, along with an RCC building standing thereon, assessed as holding number 64 of ward number 18 by the Guwahati Municipal Corporation. The records further reveals that the holding number 64 pertain to a RCC 2-story building, and the first floor was assessed as holding number 127. And the year of construction was 1978 and 80-81. This aspect of the matter is apparent from Annexure A of the affidavit in opposition filed by the Town Planner, Guwahati GMDA. It further reveals from the records that pursuant to the deed of sale dated 1989. The land was mutated in the name of Apurva Kumar Datta and Apurva Kumar Datta, bracket, since deceased, and Arun Kumar Daw, DAW, since deceased. The holding number 64 of ward number 28 was also mutated in the names of late Apurva Kumar Datta and late Arun Kumar Daw by bifurcating the said holding number 64 into holding number 64A and 64B, respectively. It further reveals from the records that in the assessment from the records which pertains to the assessment registers, for the quarters 2007-8, for the third quarter of 2007-8 and third quarter of 2010-11, that holding number 64B, in respect to holding number 64B, the description of the building has been shown as RCC third story building with a year of construction as 1997. The records also show that on 15/2/2006, late Apurva Kumar Datta expired, and on 1st of May 2009, late Arun Kumar Daw expired. The petitioners, from a perusal of the petitions, there is no mention as regards the petitioner's knowledge as to when new constructions were carried out pursuant to the deed of sale executed on 7/7/1989. But it has been mentioned that there were constructions carried out in the year 1997 on the basis of the extracts of the assessment register, which were obtained after the death of late Apurva Kumar Dutt and Arun Kumar Do. The record further reveals that on 6/10/2012, a notice was issued by the Commissioner, Guwahati Municipal Corporation, to the petitioner's hearing stating inter alia that the petitioners have undertaken or carried out development, erection or re-erection of RCC bracket ground floor, mezzanine floor, comma, first floor and second floor of the building without the permission required to be obtained under the provisions of the Guwahati Municipal Corporation Act 1971, for short, the Act of 1971, and the building bylaws framed under the provisions of section 416 bracket small I of the said Act of 1971 as specified in the Schedule A to the said notice. The petitioners were directed to discontinue the undertaken work of erection or re-erection of the erection forthwith and to show cause within 7 days as to why unauthorized construction of deviation should not be demolished. Pursuant thereto, the petitioners submitted a detailed reply on 15/10/2012 In the said reply at paragraph number 3, it was mentioned that during the lifetime of late Apurva Kumar Dutt and late Arun Kumar Do, they had constructed a 3-story building over the plot of land mentioned in over the plot of land, and the said building was completed in the year 1997. It was denied that the permission that the building of the construction of the building was without permission. And on the basis of the assessment of the holdings done by the GMC authorities, it was stated that the buildings, the construction of the buildings cannot be said to be illegal in view of the judgment of this court in the case of Jadhav Chandra Das versus Guwahati Municipal Corporation and others, reported in 1995, 3 GLT 588. It is not known what steps the Guwahati Municipal Corporation had taken pursuant to the same reply received from the petitioners. Be it as it may, the Chief Executive Officer of the Guwahati Metropolitan Development Authority had issued a notice under Section 687 of the Guwahati Metropolitan Development Authority Act 1985, for short, the Act of 1985, stating inter alia that the construction which was carried out by the petitioners were in deviation of the sanction plan issued permit number GMDA/BP/1218/2000/25 dated 14/11/2000 of the GMDA, and thereby contravene the provisions of section 24 and 25 of the Act of 1985. The petitioners were therefore directed to show cause, asked to show cause within 10 days of receiving of the said notice, why the approved of the unauthorized building should not be demolished under section 88(1) or seal the unauthorized erection or work of the premises in which such work was carried out or completed under section 88(4) of the Act of 1985. In the same notice, it was also categorically mentioned that the mezzanine floor and the second floor were constructed without permission, semicolon. The rear setback is maintained 1 meter as against 2.5 meters as per approved earlier, and 1.2 meter cantilever projection over the side margin. The petitioner thereupon submitted a reply on 26/12/2012 submitted a reply, which, as per the petitioner, was received on 26/12/2012. In the same reply, it was mentioned that during the lifetime, late Apurva Kumar Datta and late Arun Kumar Do had constructed a 3-story building over their land measuring 15 letters, covered by Dag number 914 new /1758 old, included in KP Patta number 1540 old /842 new at Sohar, Guwahati, second part under Moja, Guwahati, Moja. The building was completed in the year 1997, as could be seen from the notice under section 156(3) for the assessment of the buildings in the year 1997. It was further mentioned that as the construction part is exclusively within the domain of the GMC and not the Guwahati Metropolitan Development Authority, further to that, it was specifically mentioned that the building was constructed in the year 1997 and the same had been assessed by the Guwahati Municipal Corporation in the same year. The petitioners thereupon, the predecessor in interest of the petitioners thereupon have been paying regular taxes in respect to the G+2 building. And the fact was verified by the GMC holding assessment sheet with respect to holding numbers 308, 64B, which also allows the year of, which also shows the year of construction as 1997. It was specifically mentioned that a contention in the notice stated 17/12/2012 that the building was constructed in terms with the permit number GMDA oblique BP oblique 1218 oblique 2000 oblique 25 dated 14/11/2000 is beyond the records and the same is not maintainable in law. It is further seen from the reply that the building is a commercial construction and all buildings in the periphery of the building constructed in the area is having similar constructions. It was specifically stated that as pointing out only one building and leaving others by giving reference of a wrong NOC will be against the spirit of the equality before law. Under such circumstances, the petitioner therefore requested the Chief Executive Officer of the GMDA to drop the said proceedings. Pursuant to the said reply, on the Chief Executive Officer issued a communication on 4/3/2013 to both the petitioners, asking the petitioner to furnish the copy of the no objection certificate obtained by their parents for construction of the existing building, which is claimed to have been constructed in the year 1997. In the said letter, it was also mentioned that a letter dated number GPL oblique UC oblique 28 oblique 143 oblique 2012 oblique 13 oblique 1202 dated 29/10/2012 was received from the Commissioner, Guwahati Municipal Corporation. The copy which we have enclosed therewith, wherein it was mentioned that the copy of the NOC number GMDA oblique BP oblique 1218 oblique 2000 oblique 25 dated 14/11/2000 issued from the GMDA from the office of the GMDA was furnished before the officials of the Guwahati Municipal Corporation from your end. Be that as it may, the said document, be that as it may, although the letter issued by the Commissioner of Guwahati Municipal Corporation dated 28/10/2012 was a part of the communication dated 4/3/2013 issued by the Chief Executive Officer of the GMDA, but the same has not been brought on record by the petitioners. Pursuant to the said communication dated 4/3/2013, the petitioner submitted a communication to the Chief Executive Officer of the Guwahati Metropolitan Development Authority In the said reply, it was mentioned that as the time was very limited and the Guwahati Metropolitan and the Chief Executive Officer of the Guwahati Metropolitan Development Authority had sought all records, the petitioners tried their best to locate the NOC based upon which their building was constructed and completed in the year 1997. It was mentioned that the petitioners had inherited the property from their fathers, namely late Apurva Kumar Datta and late Arun Kumar Daw. And the petitioners were not able to were not in a position to trace out the NOC based upon which their building had been completed. The petitioners further sought for some time so that they may request the Guwahati Municipal Corporation to furnish a copy of the documents based upon which their building was assessed in the year 1997 by the Guwahati Municipal Corporation. The petitioners denied that they have been furnished the NOC number GMDA/BP/1218/2000/25 dated 14/11/2000. Petitioners denied that they had furnished the NOC number so and so dated Iman, and to the best of their knowledge, as the building was in existence on 14/11/2000, there was no need of taking fresh NOC for construction of the same from the GMDA. Pursuant thereto, the impugned order was passed on 15/11/2013, whereby the petitioners were directed to demolish the unauthorized portion of the building and stop the unauthorized use of the same in violation of the Act of 1985, building bylaws, and the zoning regulations within 5 days from the receipt of the said order, failing which the GMDA would be free to proceed with the demolition of the unauthorized portion of the building or sealing of the premises of the unauthorized construction and use of the building on its own without giving any further intimation, and expenses thereof shall be recovered from the petitioners. It is under such circumstances that the instant petition was filed challenging the impugned order dated 15/11/2013. On 19th of November 2013. The record shows that by an order dated 20/11/2013, this court had issued notice the said impugned order was stayed till the returnable date. Thereupon, by another order dated 25/4/2014, the interim order passed earlier was directed to continue until further orders. The record further reveals that an affidavit in opposition was filed by the respondent number 1 and 2. In the said affidavit in opposition, it was mentioned that various material facts were concealed by the petitioner, inasmuch as an inquiry was conducted by the Guwahati Municipal Corporation, and in the said inquiry it was found that there was a change in the use of the said building The ground floor was used as a godown and the mezzanine floor was used as an umbrella manufacturing unit. In the inquiry report, it was also mentioned that the initial assessment of the holding number 64B of Sri A.K. Datta, of late A.K. Datta and late Arun A.K. Do. Both are A.K. Of late A.K. Datta and late A.K. Do was collected from the office of the Deputy Commissioner, Central Zone of the Guwahati Municipal Corporation. And on examination of the assessment sheet, it was found that during 1997, the following structures existed. Number one, RCC ground floor of 49.16 square meters with semi-RCC first floor with 23.22 square meters. Roman 2, Assam type house of 84.40 square meters. The report further stated that in another assessment for the same building, same holding for the year 2007-8, the following structures were mentioned. RCC building ground floor of 45.6 square meters, mezzanine floor of 70.38 square meters, first floor of 44.19 square meters, plus 83.72 square meters. It was further mentioned that assessment of any building by the Guwahati Municipal Corporation is for the purpose of levy of tax, and it does not confer legality to any unauthorized building, and the authority can legally proceed to take action against such unauthorized building under the GMDA Act and the building bylaws. At paragraph number 7 of the said affidavit in the position, it was mentioned that late Apurva Kumar Datta as well as late Arun Kumar Do applied for permission to the GMDA in the year 2000, and they were granted permission to construct the ground and the first floor building, and permission for the second floor was not granted. The building was for residential use. In the approved plan site, it was clearly stated that the old dilapidated RCC structure would be demolished. As regards the reference, it was further mentioned that on 29/10/2012, the Commissioner Guwahati Municipal Corporation had written a communication to the Chief Executive Officer, GMDA, stating that stating the various details as well as informing the Chief Executive Officer of the GMDA the approval of the government by letter dated 18/7/2008 at serial number 6 as regard to subsequent notice on the building to be initiated by the authority granting permission. And as such, the Chief Executive Officer of the GMDA was directed to take appropriate steps. The record further shows that an affidavit in reply was filed by the petitioners. In the affidavit in reply, there is no denial to the NOC dated 14/11/2020 issued to the predecessor in interest of the petitioners. However, it was mentioned that the petitioners had no knowledge about such application being filed or the NOC granted issued on 14/11/2000 to their predecessor in interest. This court have perused the materials and record and also heard the learned counsels for the parties. From the perusal of the records, it transpires that the petitioners, the predecessor in interest of the petitioner, that is late Apurva Kumar Datta and late Anup Kumar Dhar, were transferred a plot of land measuring 15 acres along with an RCC building, which was assessed as holding number 64 of ward number 18 by the Guwahati Municipal Corporation. Pursuant to the transfer by the deed of sale dated 7/7/1989, the predecessor in interest of the petitioners have mutated the names in the land records as well as the GMC holding number, as well as the GMC holding number 64, and the said holding number 64 was bifurcated as holding number 64A and 64B. From the records, although from a perusal of the repetition and as well as also in the reply, affidavit in reply, the petitioners have not categorically mentioned as to when the 3-storied RCC building was constructed, except stating that it is apparent from the assessment registers which were prepared in the year 2008-9, prepared in the third quarter of 2007-8 and the third quarter of 2010-11, that there is an RCC construction of the year 1997. But in the replies so submitted to both the Commissioner of the Guwahati Municipal Corporation as well as to the Chief Executive Officer of the Guwahati Metropolitan Development Authority. There are admissions to the effect that the predecessor in interest of the petitioners, that is that is late Apurva Kumar Datta and late Arup Kumar Do, had constructed the 3-story building and completed in the year 1997. There is no materials on record, however, have been produced even after the pendency of the instant writ petition for 10 years. As regards any permission which was taken by late Apurva Kumar Datta and late Anup Kumar Datta prior to carrying out the construction of the 3-story building in the year 1997. The stand which have been taken by the GMDA authorities from the affidavit also makes it clear that on 7/8/2000, an application was filed by late Apurva Kumar Datta and Arup Kumar Daur, late so-and-so, seeking permission for construction of a ground plus first floor. And the said permission was accorded on 14/11/2000. Which is available on record, and as the same had been enclosed by the affidavit filed by the officials of the GMDA. In the said permission, along with the said permission, there is an approved plan, wherein also it has been mentioned wherein also it is seen that although the application was filed for ground plus 2-story, but the approval was only given for ground plus 1. It is also seen that from the approval so granted, the no objection certificate dated 14/11/2020, that the permission was granted for erection of a building of ground 104.36 square meters and first 104.36 square meters for residential purpose in accordance with the plan submitted by it. The sanction for construction was made with certain modifications shown by red ink in the drawings And the rear setback was directed to be of 9 feet instead of 8 feet. Huh? No. That small is a feet. 9 feet instead of 8. And the second floor was not allowed due to fire restrictions. This court further finds it relevant to take note of the submission of Mr. M.K. Chaudhary, the learned senior counsel at this stage, wherein he disputes the NOC dated 14/11/2000 as well as the approved plan. Be it as it may, but from a perusal of the affidavit in reply filed by the petitioner, it does not show that the petitioners have disputed that their predecessor in interest have applied for the said permission and was granted the NOC dated 14/11/2000. Rather, it is the stand of the petitioners in their affidavit in reply that they have no knowledge about the same. In the backdrop of the above, let this court therefore take note of the provisions of the Act of 1985. Section 24 and 25 of the Act of 1985 stipulates that any person intending to carry out any development on any land, Section 25 stipulates that any person intending to carry out any development on any land shall make an application in writing to the Guwahati Metropolitan Development Authority for permission in such form containing such particulars and accompanied by such documents as may be prescribed. The manner in which the said application has to be filed has also been mentioned in Section 25 of the GM Act of 1985. Now, coming to Section 24, it stipulates that there is a prohibition after the coming into force of the Act of 1985, that is, with effect from with effect from 1/4/1992, of carrying out any development institution or change of use of any land within the Guwahati metropolitan area without obtaining the permission in writing from the authority. Full stop. The school further finds it relevant to take note of Section 88 87 and 88 of the Act of 1985, which stipulates, which confers power to stop development as well as to demolish a building which have been constructed in contravention of the master plan or development scheme or without permission, approval or sanction referred to in Section 25 and 30 of the Act, or in contravention of any conditions subject to which permission, approval or sanction has been granted. Subsection 4 of Section 88 further confers the authority upon the Chief Executive Officer of the Guwahati Metropolitan Development Authority the power to seal unauthorized construction. From the above provisions, it is clear that the Chief Executive Officer of the Guwahati Metropolitan Authority has the power to issue, was competent and authorized in terms with the provisions of the Act of 1985 to pass the impugned order dated (15/11/2013). Now the question arises as to whether, on the present facts, the said order ought to have been passed. For appreciating for the purpose of deciding, adjudicating the said issue, said aspect, this court finds it relevant to take note of the submission of Mr. M.K. Chaudhary, the learned senior counsel, who submits that from the materials on record, it would clearly show that there was a RCC building which was conveyed to the parents of the conveyed to the predecessor in interest of the petitioners by the registered deed of sale dated 7/7/1989, along with the holding number 64. The learned senior counsel has drawn the attention to the assessment of holding number 64 as it stood in the name of the vendor of the predecessor in interest of the petitioners, that is Sri Nirmal Kumar Sen. which would show that the constructions were made in the year 1978, 80 and 81. The Learned Council further submitted that from the materials on record, it would be seen that the constructions were carried out by the predecessor in interest of the petitioners and completed in the year 1997. All these constructions which were carried out and the assessments so carried out and the assessments so made also clearly shows that the assessments were made as commercial. The Learned Council therefore submits that if the area in question is used for commercial purposes, and the building which was standing thereon was all along assessed for commercial purposes, the permission for construction, even admitting, was issued on 14/11/2000 for residential purposes, would not change the character of the building from being commercial. The Learned Council submits that if the building is assessed as commercial and the use of the building is commercial, then the FAR which is permissible would be different from a building which is residential. The Learned Council submits that this is not a case for compounding, but a case where the petitioners should be permitted to submit a revised plan, permitted to submit an application along with a revised plan, so that the construction which is there can be regularized as per the extant bylaws, on the basis of the extant bylaws. This court also had given consideration to the said aspect, taking into account that the building in question have all along been assessed by the Guwahati Municipal Corporation as a commercial building. This court is of the opinion that the interest of justice, under such circumstances, it is the opinion of this court that if the building bylaws, this court also cannot be unmindful of the fact that when the use of the building is changed to commercial, the FAR which is given, how much is the FAR for commercial? It's 2, I suppose, na? 2.5 or something. 3. Whereas residential is 1.75 or something. Na? No, obviously different. Huh? No, commercial is more. Commercial is always more. Huh? The commercial is more. Otherwise, how are you going to have in that out there in this place, what you call the fancy bazaar, all these things? The commercial is always more. Let us see commercial. It will be there in the building island. Building bylaws, it will be far applicable, far. Ah. You see here. Commercial, but for a building of mixed use, a building, here's it. You see, for commercial zone, the maximum FAR shall be 300. And the maximum coverage shall be 80%. But for a building of mixed use, that is maximum FAR shall be limited to 275. 403? 40? Yeah, that is what I'm saying. Otherwise, if you are going to have more, then it becomes different. No? The setback sizes become different, everything becomes. Beautiful. Somewhere it will be there, makes it clear. Because I think it is for residential is some 2.2 it was. And commercial is 300 or something. Huh? 300. Yes. You see, page 401. See this. If it is high density, then FAR is 225. You see it? For medium, 175. Low, 125. But for commercial zone, it is 300. Also unmindful of the fact that if the use of the building is changed, to which have been assessed by the JMC all along as commercial, then the permissible FAR, bracket floor area ratio, to which the petitioner would be entitled to, could be higher than in respect to a building which have been approved for residential purposes. This code also. However, the same could be dependent upon the present existing building bylaws. And as to whether the same would be permissible to have a building to stop. So if it is same, is permissible to stop. Under such circumstances, this court therefore disposes of the instant petition with the following observations and directions. On the basis of the materials on record, as well as the exercise of power so made by the Chief Executive Officer of the GMD, the question of interference with the order dated 15/11/2013 does not arise, for which this court is not inclined to issue a writ for setting aside the impugned order dated 15/11/2013. Number 2, the petitioners herein are permitted to submit an application before the Chief Executive Officer, Guwahati Metropolitan Development Authority, bringing to the notice of the authority concerned that the building that the building in question, which was constructed and have been in existence, have all along been assessed as a commercial building. And as such, the permission which ought to be granted to the petitioners in respect to the said building shall be a permission for carrying out, shall be a permission for commercial use. Upon such application 5, the Chief Executive Officer of the Guwahati Metropolitan Development Authority shall, taking into account the various assessment orders which have been carried out, which have been made in respect to the building which have been in existence since 1978-81, and in the year 1997 as a commercial building, and for commercial use, shall pass appropriate orders changing orders thereby modifying or thereby revising the permission which was granted on 14/11/2000 of the building for commercial use. Huh? That is what I've written. I've asked the year to consider pass order, taking into account that it has all along been a commercial. And thereupon, the GMD authorities shall take appropriate steps for revising the permission on the basis of the available Available part in view of the building being converted for commercial use. The same exercise be carried out by the GMD authorities on the basis of the extent by building bylaws of 2006. No, this has to be done now. We are doing it now.
14 will be there. 14 will be there. It is done now, 14 will be there.
So it will be now, because we are filing now. As per the, I have said, extent building bylaws of the Guwahati Metropolitan Development Authority. Next. This code further directs that the said above exercise shall be carried out by the Guwahati Metropolitan Development Authority if such application is filed within 60 days from the date of the instant order. Failing which, the order dated 13/11/2000, impugned order dated 15/11, the failing which the respondent authority, the GMD authority shall be at liberty to take such action as deemed fit in terms with the order dated 15/11/2013. It is made clear that if within 60 days, within the stipulated 60 days, as stated here in above, such application is filed, no steps can be taken on the basis of the order dated 15/11/2013 till the disposal of such application. Next, it is further made clear that in the circumstance that the application filed by the petitioner cannot be considered in view of the extant building bylaws, the respondent authority shall be at liberty to take such steps in terms with the impugned order dated 15/11/2013. Mr. Chaudhary, you have asked for more. We have given you more than that. Should have been in the meantime. It should have, by now it should have been demolished. Yes, what is the Education Council doing here? Today you have for wine.
Number 2, partition.
Yes, you have got it?
Here. Purpose of this one is
They have not been issued. Oh, this matter.
and
And the records were directed. Let us see what was the order. This court finds it relevant for viewing the records pertaining to demand and show cause is required to be looked into under such circumstances. What is the case? I forgot a bit.
here, purpose notice for this.
Ah.
That's it, finance side.
Huh?
Finance side.
Hmm.
They challenge the purpose notice the petition of one ground, side or two ground. First, they have three notice was not correct. Secondly, the notice is given by section 174(2)(a) of the GST.
Oh, that one.
Approximately as per direction of this one for the petitioners, 5 their reply, detailed reply. It is also categorically statement, so we do not. Now let's say to decide whether 2174(2) will be applicable.
But why did they ask for the records?
The purpose of records was that I challenged the audit per se. Because the audit was a subsequent audit. There was a preceding audit prior to introduction of within 5 months of that preceding audit, but intervening in this audit letter was without any exercising any right or without giving me any notice that I have made some wrong with respect to the things which I have reported in my return. Because
What you are challenging, let's see. I forgot what you have done.
Page 25.
Page
25.
25.
No.
25 is the repetition. Prayer. To show cause as to why they impugn show cause notice, which audit shall not be satisfied. Service audit proceeded with. Yes, tell me. This is the show cause notice. You are challenging page 29.
Yes, 29 also. The lordship, the Shobha notice passed with the premise that the present inquiry was conducted prior to the appointed date of CAC.
Hmm.
While the lordship, page 40.
By so and so. However, section 172A spells out that the repeal of the said act and the amendment of the Finance Act to the extent mentioned in subsection 1 of section 1 shall not affect any investigation, inquiry, verification, including scrutiny and audit, assessment or any proceedings or none. Tax dues, so and so, so and so, so and so, including, and may be instituted, continued or enforced in any such tax as such one may be. Yes, tell me,
Lordship, this is page number 43 of my petition.
what is it?
It is the audit notice. It came on 17th of August 2017.
Oh, yes,
After
yes,
introduction.
yes. This happened after that.
This happened after that. Now.
So you say that where is the question of audit?
This is the question of audit one.
Means audit happened subsequent.
Audit happened subsequently. Two, there was an audit for the prior period, which was concluded in February 2017. My point was that the same officer was conducting the audit. But the same officer was conducting a previous audit and it was concluded in 2017 February. Now, what grounds he had to conduct this fresh audit after introduction of CAC? Because the previous hearing also went to the provisions of the Finance Act. And in the Finance Act, there is no provision for conducting an audit. It is coming through the service tax rules under Rule 5A, where the commissioner can grant the power or the permission to the audit party to access the premises of an assessment. But that has to be on some basis. Now that basis is absolutely missing over here. In the Finance Act, there is a particular section 72A, which empowers the commissioner in circumstances where he believes that there are reasons that the person should be audited by a special person, which could be a chartered accountant or cost accountant, and then he can issue a notice for that particular audit under section 72A. But Rule 5A is not getting any substantive powers from a substantive provision of law. It is there in the rule book only, and it grants the power to the commissioner to allow an audit party, which includes the audit party under section 72A also, to come and access the premises and ask for the document. This was was the purpose of calling for the record.
So you are challenging the 2019 demand come show cause notice at page 29?
No.
You are challenging.
No.
Your reason for challenging is?
Not because the audit was saying,
This is for which year?
the
Which
Shobha
period?
notice-
Which period?
Lordship, the Shobha notice is for the period 2015, 16, 17, 15, 17,
Huh?
16, 17, 2 financial years.
How do you say so?
Page 49 of the paragraph.
Page
is something like, so for the part of.
Ah, rent-a-cab scheme and the work contract have not paid service tax during 15, 16 and 2016, 17, amounting to so and so. Including so and so by way of violation of the provisions of so and so. Whereas during the course of audit undertaken by the officers of remand, it was observed that the said notice had either short paid and not paid the tax so and so for the period remand to remand and wrongly away December 2020. The period of the reference substantial will get 20 to pay to the said notice by the fully restated. Yes, what is the provision you are referring to? Huh? Where is it? We are concerned with 15, 16, 16, 17. And this notice at Annexure P4 is for which period? For the last 5 years or since the financial year of last audit to the undersigned. So how does 16, 17 come into the scene with this audit? Page 54.
This is the notice for the previous period.
Understood, but how does it have any relevance?
But I just want to connect one point that this particular notice was in March 2016.
16.
March 2016.
So it won't come 16, 17.
They didn't do 16, 17 by this notice. They did the audit for the period prior to March 2015 by this notice. They started this audit in 2016. They concluded this audit in February 2016.
So it is up till 2014, 15.
Up till 2014, 15, that was closed and there was no show cause notice because
Understood. So how did this notice have any relevance?
Lordship, I'm just trying to draw an analogy.
So it's for analogy purpose. Now let us see, confine ourselves to here. I'm coming at 2.
The relevant notice at
Come at-
43.
I'll come at 2.
So, more time for the next. Where of the. Friends. Other order was from more to take into consideration. In the meantime, they were ready to find their requirement. They submitted their. Basically, what not is. Whether it's not by application or stay of the letter, same letter. Already submitted this letter.
They have submitted.
Reply.
That I know you have just submitted that aspect. We'll take note of. Let's see as to whether there is a question of law involved. So though that notice of 18/3/2016 has no relevance. How?
Lordship, what I have challenged is both the audits as well as the review. Lordship, my argument is that an audit under this Finance Act 1994 can only be done with the section 72A. Or there is one other provision which is borrowed from the Central Excise Act, that is section 40, by which the summons can be issued to a person to produce a document in case of some reason. So these are the two provisions as per the law under which some inquiry or investigation can be carried. Now, both these provisions in principle require some reasons to believe the material record to conduct these exercises. Subsequently, there was a subordinate provision under rules of the service. That was Rule 5A. Rule 5A
By way of
5A of the services. I'm just producing the copy for you. Copy. One. There's a photocopy of the.
which one?
Yes.
Which one? 71?
17 and 71, punishing of returns.
Yes.
Lordship, now section 70, it is the mechanism under the Finance Act where a person has to self-assess the tax liability and furnish it under section 70. There is a corresponding rule to which to this particular section, it says that it defines the timeline within which this returns have to be filed. But the scheme under section under the Finance Act is of self-assessment. Now, if you see Lordship section 72A, there is a provision for special audit. If the principal commissioner of Central Excise or the commissioner of Central Excise has reasons to believe that any person liable to pay service tax here and after referred to such person has failed to declare or determine the value of taxable services correctly, or has availed or utilized credit of duty or tax paid which is not within the normal limits having regard to the nature of taxable services provided, the extent of capital goods used, or the type of inputs or input services used, or any other relevant factors as may be deemed necessary, or by means of fraud, collusion, or willful misstatement or suppression of tax, or has operations spread out in multiple locations, and it is not possible or practicable to obtain full and complete picture of his account from the registered premises falling under the jurisdiction of the said commissioner. He may direct such person to get his account audited by a chartered accountant or a cost accountant nominated by him to the extent and for the period as may be specified by the commissioner. So, as per this particular section, the audit can be done under the instructions of the commissioner, but by a chartered accountant
Or a cost or a cost accountant
or a cost
nominated by.
nominated by the commissioner.
Then
Lordship, go to the rules, Lordship.
which one?
4th page from the last. Rule 5A.
Yes.
Access to the registered
Hmm.
An officer authorized by the commissioner in this behalf shall have any access to any safeguard the interest of the revenue. Every assessment shall on demand make available to the officer and forward when or the audit party deputed by the commissioner or CAC or a cost accounted or chartered accountant nominated under section 72A of the Finance Act. Now, the set of records which have to be submitted. Now, this
Then,
now this rule lordship one has been struck down by Delhi High Court.
which one?
This rule 5A has been struck down by the Delhi High Court, saying that it is not constitutional, it is ultra violates the provisions of the Finance. Because under the Finance Act, there is no provision which substantiates this. There is no power to substantiate this. One. Lordship two, the audit under the Finance Act, the scheme of Finance Act, is not a regular or a routine mechanism. An audit can be conducted only in specific circumstances,
When he has reasons to believe.
when he has reasons to believe.
Then,
Now, my submission is Lordship. He conducted my audit for the period up to 2015. There was no bar with him to carry out the audit for the subsequent period because he started the audit on 18th of March 2016. Then later, Lordship was represented. And he continued that audit till 2017 February. Now, within this period, the Finance Act was operational, it was applicable on me. Now, after introduction of GST, he issues another notice under Rule 5A, which has been struck down by the Delhi High Court. Prior to this notice only.
which notice?
Lordship, it is at page number 43.
3.
It is dated 17/8/2017. Now he says it is to be informed that your unit is scheduled to be audited by the Central Excise and Service Tax Audit Party in this connection. There's no reason which he is giving. This is a standard format which he is following.
It is required to disclose the reason.
No, not this.
He has to only record it.
He has to record it. Absolutely. But my point is, Lordship, when he was sitting in my premise, the same officer is issuing this notice also, he was conducting the audit. Now, he was sitting in my premise and conducting audit for a particular period. Now, for issuing this particular notice, after introduction of GST, he must have had some reasons to believe, which was my argument in the previous hearing, for which the file was asked for on the record.
So you say that there has to be reasons to believe for this issuance of the notice of
Not-
17A.
Lordship, the argument, legal
Because
argument.
this is not done under 5A.
This is under 5A. If it is
No,
not-
it can't be under 5A.
If it is not under 5A Lordship, then there is no provision under the law under which this notice came.
Why?
Lordship, because 72A, this has to be conducted by a chartered accountant. Now, this has been conducted by the officer of the department.
So
Lordship,
72A gives the power. Rule 5A does not give the power for that. Rule 5A only stipulates that when a person concerned, 5A, first part of our Rule 5A says that if a person concerned has been nominated by or anybody who have been appointed out there by the commissioner, they shall produce these documents and all for that purpose. And number two, as regards, they will have the power which is being exercised by an officer. That is what 5A is supposed to show. So 5A, let us assume 5A is not there. But then also, what is the, can't they issue this under 72?
72A Lordship. Lordship, it specifically says that he may direct such person to get his accounts audited by a chartered accountant. This is a special audit, Lordship, which has to be done by a chartered accountant or a cost accountant.
Yes.
This has been conducted by the departmental officer. So my audit has been conducted by the departmental officer.
Hmm.
Now 72 specifically talks about chartered accountant and cost accountant on the instructions of the commissioner. And then commissioner must have the reasons to believe that this audit has.
No, what happened to 72A after the GST has come into source?
Lordship, 72A was of the Finance Act. It is not particularly saved by the.
No, I am asking you, whether 72A remains after the GST has come into force.
Lordship, because GST law has a separate mechanism for audit.
This is done under GST.
This is done under the services.
But does the service tax has a different mechanism after the GST has come into force?
Lordship, under the GST law, there are two provisions. One, that a person has to get his accounts audited himself and file on year-to-year basis. And that,
Under the GST law.
under the GST law, and that account has to be signed, the final report audit report has to be filed by a chartered accountant. Subsequently, that provision has been taken. For the initial years, that provision was there. There was no role of the commissioner in that. That was a suo motu audit exercise. Other one is, there is a specific section under the GST law which empowers the commissioner or the department to conduct the departmental audit of DSS.
So what is wrong with this notice then?
But this notice is not under the GST law audit.
It is under,
This is under the service tax law.
how do you say so?
Lordship, this notice is to conduct the service tax audit. It is not to conduct the GST
But
audit.
the service tax remain after 1/7/2017.
If that is the case, Lordship, then this notice cannot be issued, because what he is asking is, he is asking me to submit the details prior to 30th June 2017, prior to introduction of GST. He is asking me service tax detail in a GST notice. That will not,
Are the provisions of the service tax saved by the GST Act subsequent thereto, if any proceedings was not initiated on the basis thereof?
now, Lordship, this is the point which I am trying to do. The provisions are safe if the proceedings are initiated. This is not my case. In my particular case, the proceedings initiated after introduction of GST. One. Two, Lordship, in my particular case, the department has not accrued this right to conduct this audit.
Why?
Lordship, they have not done any, they just had this provision in another finance act. They didn't had, they haven't done anything to accrue this right. I'm saying this because as per the instructions issued by CBIC, for conducting an audit, there has to be some risk assessment basis which this audit has to be conducted.
That is a question of fact.
Lordship,
That's a question of fact.
Lordship, this is also a question of law, Lordship,
It
because
can't be a question of law. It has to be a question of fact. Then why should this court at all
Lordship,
embark upon these aspects when the matter you have already submitted your reply?
Lordship, I have submitted the reply one to show the notice under the instructions of this honorable court.
Are you saying that this court had given the instructions to you to submit?
Lordship, that was the order of the court to file a reply to the local court. It was
Because this court didn't want to stall those proceedings pending the disposal of the writ petition.
Lordship, but then the court also.
You want this court to dismiss this reputation, will dismiss it so that you can take and thereafter take recourse to whatever proceedings which is available.
I'm not, I'm
Kindly
saying,
don't say that it is at the instructions of this court.
Lordship, the order was read that way.
Is it so? This court has granted instructions, issued instructions.
That is my.
My goodness, it can't be this. You are given the liberty. Petitioner is allowed to submit the detailed response before the authorities within 4 weeks from today. In that view of the matter, the petitioner is allowed. You may or may not.
Even if I have filed a reply, Lordship, then also the proceeding which is not permitted by the law. does
So
not-
show me. As of now, you have not been able to show me.
Lordship,
You have to show me that after the GST has come into the scene, then they cannot exercise this issuance, that there couldn't have been the issuance of this notice on 17/8/2017. Show me that. As of now, this court is not satisfied.
Lordship,
No GST account. What is that?
there is a judgment which I am referring to.
First, show me the provision. We'll go into the judgments later on.
Lordship,
Are you saying that the GST Act does not stipulate what happens, how are the all other proceedings prior to the GST Act saved?
Lordship, it is there on page number 11 of my.
We'll see later on. First, show me which is the provision for the GST Act.
Lordship.
This is done under the CGST Act.
This is CGST Act, which is Saving the Finance Act provision. 174.
Hmm?
174.
174 will come later on. First of all, let us see the assessment, how it is to be done. Returns here. Save and accept otherwise provided in the site.
Then,
So 174 2D,
E,
2E. Ah, yes, 2E. So those are saved.
yes, sir. And Lordship, this issue has already been decided by our High Court. Several, it is same question of law was raised.
Where is it?
Lordship.
Yes, which paragraph you are referring to?
That we look at for the case.
Now, Mr. Kyle, tell me under what provision you have initiated that, issued that particular notice,
Page 41.
page
Page 41, paragraph
of the,
eight, it's
page 41.
first.
No, not the so cause. This, page 43. And is the so cause notice based on such audit?
It is emanating from this order.
How do you say so?
It's there in paragraph 1 of the.
Hmm?
Paragraph 2 of the social notice, page number 30. Whereas during the course of audit undertaken by the officers of the Supreme Court audit consulting,
Where it appears?
whereas page number 30, paragraph 2, whereas during the course of audit undertaken by the officers of the Supreme Court audit consulting, check with observe that the said notice, that noticing has this sorted or not.
Not be the late submission of. So it is on the basis of this audit which was done on 17/8/2017. Under what provision is this audit? Hmm? We'll see from the records. Because now I remember his submission was on that day. That is why I called for the records, that as the audit which was being done for the period for 2015-16 and 16-17 is on the basis of 17/8/2017, which came into effect after the GST has come into force. And as such, this audit is not saved by 174(2)(e). And as such, if it is not saved, then they ought to have taken it under the GST Act, not under this. No, but it was not saved. That portion has not been saved. You are saving such. 174(2)(e) only saves certain aspects. But have you started it on the basis of 17/8/2017? And if that be so, could you have done so for the earlier years? Under the Finance Act, if you had that has not been saved. Was that not your argument? You are making a different argument to me. That is where I want to see the records. Show me. Under the GST Act, where is the scope of audit? 65. Auditors by tax authorities. The commissioner or any officer audited by him by way of a general or specific order may undertake audit on any registered person for such period at in such manner and may be prescribed. Referred to and may conduct audit in the place of the records of the registered. The manner shall be done by the shall be So here special audit by the authorities is 65 and 66 is for,
The special law,
which is 72A.
which is 72. So this corresponding section.
Now, are you saying that 65 cannot be done in respect to the earlier years?
So section 65 says in respect of the registered person.
You are not registered.
Registered person is under this sect, the CGST Act.
You are not registered.
Lordship, I am a registered person under the CGST Act, but for the purpose of GST. For the Finance Act, there was a separate registration given to me by the government.
No, I'm not on that. Are you saying that once the act has come in on 1/7/2017, thereafter, all earlier periods, there cannot be an audit
Lordship, there can be an audit. One,
under 65?
Lordship, one audit is not a routine exercise.
No, this is a routine.
Let us see. No, under-
65 is routine
Okay.
by
Under
general or
GST law,
specific audit.
GST law, there is no provision to conduct any audit for this Finance Act, Lordship. Because, Lordship, under section 142 of the CGST Act, there is a specific provision. It says that all the previous assessments have to be done in, under the, previous acts, the existing law which has been.
Where
Section 142.
where any goods on which duty, if any, has to be paid in the existing, and had been paid under the existing law at the time of the not being earlier than 6 months prior to the appointed date, are returned to any place of business where
Lordship, subsection 8, Lordship.
Huh?
Subsection 8 of section 142, wherein pursuance of an assessment or adjudication is instituted whether before or on or after the
Pursuance of an assessment or adjudication
Under the
instituted
existing law.
whether before or after under the existing law. Any amount of tax, interest, fine, or penalty becomes recoverable from the person, the same shall be unless recovered under the act be recovered at an area of tax under this act. So recovered shall not be. Where? This has nothing to do with that.
Lordship, it empowers that assessment.
This is a different thing. Assessment or adjudication instituted whether before or after.
Sure.
Under the existing law.
Sure.
Any amount or tax, interest, fine or penalty shall be recoverable. That is only on that. But you see, audit is how the audit is to be done or who shall be the authority. We are only on the question because your specific question is you are challenging 17/8/2017 on the ground that if 17/8/2017 is done under the Finance Act, it has to be done only by a chartered accountant or a cost accountant appointed by the commissioner.
Lordship.
Secondly, there has to be a reasons to believe.
Sure.
These two, without these two aspects, there could not have been done.
Sure.
On the other hand, now we see section 65 of the GST Act permits
Sure.
by a general or a specific order to conduct tax. But it is only in circumstances which comes under section 66. Then only a special audit is envisaged.
Lordship. Now, under section 65 also, what has to be assessed is a GST tax, not the finance, not the service tax. Lordship.
How do you say so?
Lordship, because the audit is conducted for assessment of tax under the CGST Act, Lordship.
Where is it? The commissioner or any officer authorized by him by or any general order and may undertake audit of any register for such period at such frequency in such manner as may be prescribed. Where is it mentioned? That it is only for that act? Unlike in 142, it has been categorically mentioned.
Lordship, it is not specifically mentioned, but this is
We should-
entering under section.
Should we add it? Should we add it?
It's not the point of adding. I'm just saying that this particular section is under the CGST Act, which empowers the officer to conduct the audit of a registered person. Now, the registered person is under the CGST Act. He will be assessed for the CGST only, Lordship. Corresponding provisions are there in the state GST Act also, whereby the state officers are empowered to carry out the audit of the registered person to assess the state GST. Now, the question under sections, the question to conduct audit of the Finance Act under section 65 does not arise, Lordship, because this particular provision is specifically related to CGST Act. It has nothing to do with the Finance Act, Lordship.
What does CGST Act stands for?
CGST Act stands for the Central Goods and Services Tax. Lordship, Central Goods and Services Tax is defined to be a specific law which is applicable on supply of goods and services under the section 7 of the CGST Act. Now, my transactions were not under CGST Act, they were under the Finance Act.
So,
Now, how can 65 be applied on transactions which are outside the preview of CGST Act? The audit can be conducted. with
are you
respect-
saying that any services which have been done under the Finance Act can't be brought under the Central Goods and Service Tax Act?
No, Lordship, because Central Goods and Services.
So therefore,
Act is applicable-
are you saying that 174 does not save anything in respect to those Finance Act?
Lordship, it saves the audit which is instituted. Already instituted audit is saved, Lordship.
Understood. But if there is no audit, it means, are you saying that there can be no audit?
No, Lordship, I'm not saying that there can be no audit. My point is that this is the.
No, here is the case, there was no audit carried out. For
Lordship,
2000
audit is not a routine exercise which has to be necessarily carried out.
No, it can be a routine exercise under 65 because it is by a specific or a general order.
For the purpose of CGST.
It is only for the special audit. No, not for that. I'm saying only for a special audit. Now, you see the Finance Act, as per this act, the Finance Act of 1994 has been. What happened? Has the Finance Act not been? Yes, Finance Act 1994 has been repealed.
Lordship,
Then, under what provision did you pay the service tax?
Lordship, if I have to pay service tax, I have to pay under the Finance Act only, Lordship.
So, that means there is no tax any further.
No, Lordship, it is with respect to the Finance
So
Act.
if it is not saved, if it is not saved under 174E,
Lordship,
2E, then what happens?
Lordship, I'm not saying that audit.
Just for example, on 30/6/2017 is the date, or because 31st is a different date.
Lordship, because.
First, the GST comes in. If a person wants to hold an audit, that the audit is required in respect to those transactions which have ended up till 30/6/2017. Are you saying if they don't take any steps, it will go?
Because for 36/2017, there was a specific provision in the CGST Act as a transitional provision, which provided that you have to file your return within a specified time period, so that assessment can be made under the Finance Act. The period April 2017.
Filing of a return is a different thing. We are not concerned. I am saying about the power of audit.
Lordship, for this particular.
Does 142 take care of the power of audit of 172A? No.
Lordship, I just refer to this particular situation about 30th of June 2007. There is a specific provision.
Mr. Kyle, as per me, the issue is, although it has been made this way, that way, is very short. The issue is simple. Is to whether, the question is, if he cannot challenge 17/8/2017, he has nothing to, there's no problem with the so-called notice, the authorities can take up. Whether 17/8/2017 could have been issued. His case is, it should have been done under 72A. But 72A was no longer there in existence.
Yes.
What has been saved under 174(2)E is only which have started. If you have not started, then what happens?
After any investigation, inquiry, investigation, including scrutiny and appeal, assessment proceeding, adjudication, any other legal proceeding, or recovery of evidence, or negating in respect of punishment. Penalty, fine, offense, delay, obligation, or punishment is imposed, penalty, investigation, investigation, assessment proceeding, adjudication of the other legal proceeding. For the review of evidence, maybe distributed continue to enforce. And officers place such as maybe fine state officer, maybe the lead and the court, maybe this may no something acceptable. Says that the people say.
So therefore, 1994, that act was repealed under 173. But he must have submitted his best judge, his returns as per 70. He must have done that. Now, you have initiated a proceedings and on 18/3/2016 for certain years. Those period is okay, but that was only up till 2014-15, not beyond that. This show cause notice which have been assailed is for the period for 2015-16 and 16-17. Now, in that respect, although this audit is sought to be done for another 5 years, last 5 years, meaning thereby from 2017 onwards, last 5 years, from 2011, 12-13 onwards, 12-13, 13-14, 14-15, 15-16, 16-17. So this is from 12-13. You are saying earlier it was from 11-12 or something. Okay, but it's done. Now we are concerned with 2015-16 and 16-17. Now in this case, what has happened? You have issued a notice for holding the audit, and accordingly he must have participated in the audit or not. That I is not known. You have participated. And thereupon, on the basis of the findings, you have issued the show cause. Now, here challenge the show cause only on the question that your basis of the show cause is the audit report. And the audit report could not have been done. If it was done, his cases, it should have been done under 72A. And if it is 72A, then in that case, you have to have first the reasons to believe on the circumstances which have been mentioned in 2A, B, C. And thereupon, you can't do it by yourself. You are to appoint a cost accountant or a chartered. This is his basic case. Now here, it has been done by the tax authorities. We have section 65, which permits by general or special order to do so. Meaning by, if it is a general or a special order, you don't need to be relevant to those facts or having a reasons to believe for that, which is otherwise there for 66. So 65, you can very well do so. Now, if it is so, could you have done under 65? Under what provision you have issued this 17/8/2017? If you have done under that, then could you have done under 72A in this manner without forming reasons to believe? You may have it in your records. Could you have done by the tax authorities, taking into account the mandate of the Act says cost accountant and chartered accountant? That is it. For that, let us see the reports for which we have fought.
And to the record.
Yes, there is nothing to that.
I contains where of the document. They sent to file, but regarding heat, there is no material.
Hmm?
There is no material available in the present for either the NOC or any document is available with regard to file for initiative.
That is the reason why we have called for the records.
And the record that contains from the expense of the property is finding of the
Reply will be different because you base your so-cause on the basis of the audit. Now, another aspect. After 1/7/2017, you have not put the provisions, whether you have done under the Finance Act or under the AI Act. Where?
Paragraph 1. Page 29.
Yes, where is it?
In first paragraph, the state inquiry was affected for the defense of the central goods and service tax of 2005, section 173 of the state act, chapter 5 of the financial act report, and had been omitted. However, section 174 of the CSP Act 2017 found that the repeal of the state act
Now, that I have understood. But where is it mentioned that you have initiated? What inquiry did you start? For 2015, 16 and 16, 17. We are concerned because the so-called notice is specific for these two periods, not for earlier period. Yes, where?
No, because
What inquiry did you do before that?
this paragraph 2,
Yes.
the remaining parts of the office are taken by the results of the government office. Was the audit notice which was issued on 17/8/2017. This is with respect to that audit,
Now that I understand.
and that audit is being undertaken under the Finance Act of Chile Lordship.
How do you say so?
Lordship, because there is no provision as such under the DSA one. Two lordship, this is an.
Why 65?
Lordship, lordship, the assessment under 65 can only be with respect to the CGST at lordship.
The survey. So are you, therefore you are saying, are you saying that anything which is left out? Just for example, there was no proceedings initiated. You have submitted your returns. Let us assume under section 70, you have submitted your returns. There must be a period of limitation within which they can have an audit.
There is no period of limitation for conducting an audit.
No. For this audit is for what? For investigating as to what has happened. Now, you have made a self-assessment, you have submitted your assessment. There's a best judgment to be made.
Sure.
The best judgment has to be made on certain other materials which is available.
Okay.
So if he wants, within what time can a best judgment
Not-
be made?
Lordship. In fact, it is there in 72.
72.
72 is the best judgment.
What time?
He says if any person liable to pay some tax pays to furnish the return. And having made a return pays to assess the tax in accordance with the provisions of this section, the central excise officer may require the person to produce such accounts, documents or other evidence as he may deem necessary after taking into account all the relevant materials which is available and all which he has gathered. Shall by an order in writing, after giving a person opportunity of being heard, make the assessment of the value of the taxable service to the best of his judgment and determine the sum payable by the assessee or refundable to the assessee. Time limit law. There are a couple of texts that it has
Now, how do you take care of 73?
73, there is a limitation period law.
18
There is
months.
an extended period of limitation. plus
18 months.
18 months is
18.
the normal period of.
So if it is within 18 months, they have the right to make a special audit.
Lordship, that section 73 is with respect to the issuance of notice. It is not with respect to the audit.
Audit is for what? For finding out. We have not bought these same things, and as such, I want to know these aspects. And this is how I have formed the opinion on this. And as such, this is the basis on which I am appointing a cost accountant or a chartered accountant to do so. On the basis of that, he may carry out the best judgment also.
Lordship, we could have carried out best judgment, but in this particular case, we have not done so. Because for conducting best judgment, there has to be a specific procedure. That has not been done. One. Lordship, second, the section 73 is a specific section which empowers for recovery of debt by issuance of a notice.
Yes. If it is short levied,
If it is short levied or short paid.
short paid.
No, it's
Oh, no,
not-
is there no provision of a sumoto revision?
No,
or
Lordship,
revision?
there is no, unlike income tax law or the VAT law, there is no provision for the revision or reopening of the system.
Now, let us see. How do you take care of 73? If there is a case of fraud or collusion or willful misstatement or suppression, contravention of any other provision.
Lordship, I have been audited continuously.
No, I'm not concerned with that, how many you are. But he has a reasons to believe.
Lordship, it is not coming out what are the reasons for belief for to issue a notice after this.
That is, there
That
is
is the
no,
question of jurisdiction, Lordship.
no. You see, there are many judgments in the case of the Income Tax Act where it is said that you don't need to disclose your reasons.
Lord-
Reasons to believe may be kept out there, they have to only record to file. So under such circumstances, that reasons to believe will take care of it, whether it is there. But take a circumstance, in this case, if it comes under the proviso, it's a case of fraud. And under, or anything which is being brought out there for which he wants a special audit. What is he going to do if he, within this period, GST comes?
Lordship, it's quite- it is a peculiar situation.
He is going to resort to 72A now.
Lordship, we could have resorted to.
No, is he going to resort to after the GST, this provision is not safe?
Lordship, now that is there in the law. Now, the point is that section 73 is a subsequent exercise. It is after some audit or investigation, special audit or business.
For making a special audit, you see, how will a person discern let us take a hypothetical situation. A person gets some information on the basis of which he wants to have an audit done so that as to whether there is a fraud. In the meantime, the GST comes in. Then what do you do?
Lordship, can we go on a premise that there will be fraud?
No, I'm not. I'm saying on a hypothetical because we are on these situations. That a situation has arisen where, as per you, nothing was done prior to your submission of your returns on the 17th. And in the meantime, the GST had stepped in. And pursuant thereto, they have taken steps under for issuance of an audit on 17/8/2017.
Lordship,
Therefore, the question arises, I'm putting a hypothetical situation. You submit the best judgment. After doing the best judgment, some information comes to light. Yes, these are there. But he wants to have an audit. Are you saying that he has to then resort back after the GST has come in to the Finance Act 72A?
Lordship, that is the only section under which an audit can be done for the purpose of Finance Act. Lordship, if he had three reasons to believe that he would have easily invoked the extended period of.
Where is that provision of 72A saved? That is not saved.
Lordship,
Are you saying that the state, that the authorities will be completely powerless?
I'm not saying that.
How can you go back to 72A? 72A has not been saved
Lordship, if 72 is not safe, then
because your basic submission is they have not taken any steps.
yes, Lordship.
So there is nothing remaining as on 1/7/2017.
if that is the situation, Lordship, if 72A is not saved, then they can't take benefit of the CGST at Lordship.
Why not?
Lordship, because.
When there is a provision, are you saying that a person may, the moment another act comes in, so anything which is payable or any fraud which has been committed can be, cannot, the authorities shall not have any resort.
I'm not saying that, but under CGST Act, they cannot assess the tax liability of the Finance Act.
I'm not saying about the tax liability of the finance sector. I'm saying whether they can't, why can't they make an audit under 65?
Lordship, because audit under 65 is of the registered person and the person who is carrying out the transactions of supply under the CGST Act. The taxable event of CGST Act has to be audited under section 65.
So you are saying that there was no taxable event of under the Service Tax Act?
Service Tax Act had a separate taxable event, Lordship. That was under section 65 of the Finance Act 1994. That is a different taxable event of carrying out an activity for consideration between two persons. Now, under CGST Act, there is a different taxable event which is supply of goods or services, which is advisable to CGST Act, CGST as per the CGST Act. An audit under section 65 can only be done with respect to the CGST. A taxable event which is not arising under the CGST Act.
But that provision of, as I'm saying, repeating, 72A has not been saved.
Lordship, 72A is not saved if the.
So that means after the period is over, after the GST comes in, you said for the earlier periods where there has been service tax involved, there can be no audit.
There can be audit.
Under what provision?
Under 72A.
How? 72A is not saved.
Lordship, if they had
You
initiated
see,
something
no,
prior,
no, if it is not initiated,
then Lordship, my argument is that it is not saved.
that can't be the proposition. If that is the proposition, it will have a far-reaching consequences. No. That can't be the proposition.
Lordship, I relied on a judgment last time.
Where? Hmm.
Page number 51.
Yes.
This is Ravi Electronics.
Huh?
Ravi Electronics.
Ravi Electronics, yes, 41. Yes. What did it say?
Page number 51.
Hmm?
Para 36.
Page?
Page 51, para 36.
Yes.
Lordship, there is a slight difference that in sales tax act, there was a provision for reopening of the assessment. While in finance act, there is no provision for reopening. We may recall that the petitioners had filed the returns at relevant times under the sales tax act. Such returns were also processed as per the provisions of the Senate. Till the sales tax act was repealed by the VAT Act, no further action was taken by the department. To be precise, no notices for reopening of such assessments were issued till the sales tax act was repealed. It is true that the sales tax act permitted period of 8 years from the end of the period to which such turnover related for issuance of the notice of reassessment. If the commissioner had reasons to believe that the dealer had conceded such sales or any material particulars thereof or mainly furnished incorrect declarations or returns. However, in our opinion, mere right to issue notice within the said period cannot be equated with accrual or incurring of any obligation or liability. If the notices were already issued, it may have been possible for the department to contend that the SSC having already been visited with such notices, the liability to be reassessed have already accrued. And any repeal of the sales tax would not obligate such liabilities by virtue of provision of section 1 of section 100 of the Act.
Then
Lordship, my returns are filed. There is no provision for reopening of the.
No, you're reopening, there can be a year under 73. Under 73, if there is a case of fraud, non-disclosure.
Lordship, I have filed my returns.
Under 73, they may ask for you within 5 years.
Lordship, under 73, they can issue a notice. But prior to that, they have to do some audit. And that audit has to initiate prior to introduction of GST. That is my point.
What is your basis on that?
Lordship,
That the audit has to be prior to the GST.
Lordship, this particular judgment in fact is saying that they have to issue notices prior to the repeal of sales tax. That is the exact proposition which in my case, even if they have to go to section 73 and invoke the extended period of notification, then the special audit at least has to initiate prior to this.
Difficult, Mr. Counsel.
Lordship may give me a short date as this.
What short date? What more short dates? You have already spoiled so much of time. What is this spoiled short date in?
Lordship, my submission is that they have not done anything prior to introduction of GST. They could have issued a notice under section 72.
Then how you take care of 142.8? 142.8 gives them the right to do it.
Lordship, if they had initiated something.
You see, the moment you have submitted your return, a right continues upon them in view of 142.
Lordship, if I have submitted my returns.
You
There is
see,
only one provision.
142A, where in pursuance of an assessment or adjudication proceedings instituted, where the before or after the appointed date under the existing law, any amount of tax, interest, fine, or penalty become recoverable from the person, the same shall, unless recovered under the existing law, that is the Finance Act, be recovered as an area of this law. Then you see here, finally see 9A, where any return furnished under the existing law, this is what, is revised under the after the appointed date. And if pursuant to such revision, any amount is found recoverable, or any amount of send-back credit is found to be inadmissible, the same shall, unless recovered under the existing law, be recovered as an area of tax under this act, and the amount shall be recovered so as to be admissible, not admissible for input tax credit. Now, if that be so, the revision, the power of revision, let us understand 73. If there is a case of fraud or a misstatement or willful not disclosure of this fact, and you submit it, your return under your judgment, self-assessment under 70. If that be so, are you saying there can be no audit if it has not been done prior to that?
Lordship, 73 is not empowering to conduct an audit.
No, I'm not saying. 73, you see, you have a power. Just for example, if I may have you a date. You submit your on 30/4/2017. Your assessment, self-assessment. After that, the matter is being found, some documents are being found out, and on the basis of that, after then how much? The limitation is 5 years. Let us say another 1 year or 2 years in 2018. They come up out here that they get these documents and they want to make an audit. Then look here, these are the audits we need to find out.
My point is that
Your submission is you can't make this audit
Lordship,
because 72 is A is not safe. 65 you can't because that is not for that,
Lordship,
and as such it cannot. That is your submission.
not one more point, because the example is the Lordship view. In a situation where something is found and this 73 has to be invoked, my exact proposition is that something finding had happened before the repeal of Finance Act. Because
It can be found later on. You have the time for 5 years.
Lordship, but then section 70, then they can issue a notice only under section 70. If 72A is not saved, Lordship, then how
That is what you say, that as 72A has not been saved,
Okay.
you are to go to, you can't go to 65.
Lordship,
And as such, the question of audit doesn't arise.
Lordship. And
And if you do, if assuming 72A is saved, it has to presuppose that you have reasons to believe on the existence of the facts which have been mentioned in 2A, B, C, and thereupon appointing a chartered accountant or a cost accountant by the commission.
Lordship. But this particular audit has not been done even under 72A. It is under Rule 5A, which is already has been held to be ultra virus the Act.
Where? How are you saying to be done under 5A?
Lordship, this audit has been done by the department. Lordship. There is no particular. There could be only two situations. Lordship.
No. How are you saying to be 5A?
Lordship. There could be only two situations, Lordship, under which department would have done this. Under 5A or not under 5A.
Where is the question of 5A coming into the scene again?
Because Lordship.
5A is a rule,
Because.
empowering under 72A.
Lordship, because 72A is
72A gives the substantive power
for
for having an audit, special audit.
special audit.
And on the basis of this 72A, a power has been given to those persons who have been appointed for the purpose of affecting the compliance on the basis of 5A.
Lordship.
Okay, how are you saying that it has been done under 5A?
Lordship, I take that argument. Lordship, my condition is if let's assume that 72 is safe. Even in this situation, Lordship, this audit has not been done under 72A. This audit has been done by the departmental officer.
So department, therefore the question is,
The department.
if 70, you see, your name? Yes. Mr. Gupta, revolving around everything, the question therefore arises out here is as to whether first after GST has come in, could they have exercised 65? If that is the question. And if they cannot, you have a case. If they can, you don't have a case. Matter ends there. What is there the more CAD? Judgment is out.
একো বুজি পোৱা নাই এটা শব্দ বুজি পোৱা নাই বুজিছে ন বেলেগ কেছৰ পৰা অকণ কিবা অকণ গম পাওঁ কিন্তু দায়ী কমাণ্ডালটো বুজি পোৱা নাই
Not the affidavit. How much is the amount? Hmm? Where is it? It is not in record. In your affidavits? Anyways, does your affidavit contain everything? So where is that book you have given? There's some judgment which you have given, na? Where is that? এখন ইয়া দিছিল সেইটো।
Company
I've referred to two judgments. Where is that? I've given it to you. One. Mafatlal is okay. I'm not on Mafatlal. I'm saying on the other one, wherein I've said that when a thing is exempted, meaning thereby it is the tax is the cess has been subsumed. It was something in 2014 or something, I forgot. PK ruling. I gave an SCC online, SCC citation. Impact of exemption. Yes, paragraph. The first aspect of the argument of the respondent is with respect to the impact of exemption upon the liability. In our opinion, exemption can only operate when there is a valid levy. For if there was no levy at all, there would be nothing to exempt. This is the aspect. The court faced with an argument which is similar to the one made before us. The case involved an exemption notification issued by the state government and reduced the liability of tax on the rear to the extent of tax paid under the ordinance in its claimed that it was entitled to adjust the entry tax paid under the entry tax while computing the so and so. Crucial question, therefore, is whether the appellant has any liability under the Act. The question of exemption arises when there is a liability. Excisability to tax is not the same as liability to tax. The former depends on the charge created by the statute and later on computation in accordance with the provisions of the statute and the rules framed therein under. It is to be noted that liability to tax chargeable under Section 3 is different from the quantification of the tax payable and assessment. Pay tax and the actual payment of tax are conceptual, but for exemption, the dealer will be required to pay tax in terms of Section 3. In other words, exemption presupposes a liability. Unless there is a liability, question of exemption does not arise. Liability arises in terms of Section 3. Makes it clear that exemption does not negate a levy. Despite an exemption, the liability to tax remains unaffected, only the subsequent requirement of payment of tax to fulfill the liability is covered. So this is it, paragraph 22 to 24. So therefore, when the GST and the CGST have exempted the payment of agricultural cess, it presupposes that the tax is liable to be paid under those enactments. And if therefore the Supreme Court here says that payment of tax and liability for tax are two different aspects. Liability will be there. So if they continue to be liable under the GST or the CGST, GST, what do you call the state GST and the central GST. They will continue to be liable. But there is an exemption being granted on the basis of those notifications. And so as such, you cannot take. It is already been taken over by the GST. Division bench says something, says that you can continue. But did the division bench take into account the effect of the GST? Understood, but tell me, did the division bench, while passing the order, have taken into consideration the effect of the exemption notification by the GST and the SGST? This happened when? When is the order of the GST, of the division bench? Huh? The GST, but let us see the division bench order. Where is it? You have submitted a written submission on behalf of so and so. Where is it? What is the submission? This was for the period earlier, because the writ petition was filed in the year 2015, and there was a direction for refund. So at that point of time, whether you were justified, because we are not concerned at that point of time, because GST came only on 1/7/2017. A refund is okay. Refund you pay it to the where? Whom? Government doesn't want. So here there was no, hence the order passed by the land on merit is upheld. So it was held that you could not have collected, but the direction for refund was set aside. So then how is this judgment in your help? Refund. But can you be allowed to keep this cess which you have collected? Understood? There are prior to that. Once when there has been an exemption granted by the GST and CGST, could you have collected? And if you have collected, should it remain in due? What have you stated in your affidavit? Have you stated, yes, poor state of affairs of the Agricultural Marketing Board? We are not in a position to run. Have you stated all these things or not? Huh? Show me. It. And if that amount is given, the marketing board would cease to exist. No, that affidavit which has not come on record. Where is that?
If I have only arranged the amount, as per the lawsuit, like able to the details are.
Give it to me. Because how much?
Yes, yes, some 2,99. Keep the
Hmm?
and here actually in numbers. It's an income. Server, we have them. Regarding the, you have
You have given for Sitaram Rameshwar, then for Krishna Trading, then for Rathi Traders, Aksaram Ampit Pincha, More Enterprise, Jai Shri Rajasthan Stores, J. Bajrangbali Food Stores, Modi Enterprise. Huh? Where? You have not given those. This is for Jorhat. Are these cases all from Jorhat? Then what about Sipsagar and Sunitpur? You have got it? So what is the total amount? Oh, you have filed separate affidavits. Okay.
And amount, the election amount, the quantity, name of community, the collection of care form, serial number. 1/7 to 12 to 2020. Date of collection.
How much is the total?
There is no.
Huh?
That's time. Regarding 16 lakhs, 37,428.
Mr. Counsel, you listen. Today is 21st. We will have it again on 28th. On that day, let these affidavits come on record. You file a very short affidavit stating that what is going to happen if your amount is returned and what is the present financial status. So that I can save you But if you don't, I have to give it to some other authority, not to them, some other authority. Okay, very well. I am not going to report. You just give it. This is what I am helping you out. Up to date. Mr. N.J. Gogoi, the Learned Council appearing on behalf of the Agricultural Marketing Board, submits that 3 affidavits have been filed for the districts of. The affidavit have been filed pursuant to the order passed by this court on 31/8/2023. However, the said affidavits are not on record. The registry is directed to bring on record such affidavits. Ms. H. Jain, the Learned Council appearing on behalf of all the petitioners, submits that the petitioners, some of the petitioners have also filed their affidavits. The registry shall bring on record such affidavits. List the matter again on 28th. We'll have it on 3rd of October 2023. At the top of the list for final disposal. Thereafter, no more charter, enough. Because of you, the matter gets getting delayed. Even here, who told? If hello, Vito, next continue.
Item 17.
Yes,
Narrow campus only, madam.
narrow compass, I remember.
That is, because Archaeology will already allow them to operate, madam.
They are operating.
They are operating, madam. Only our grievance is that we are the neighbors, madam, and it was in the pilot. And then as on the basis of our objection, madam, the deputy commissioner, there is an extra 640, madam.
Hmm.
Notice to him, madam,
Hmm.
to give a proposal for shifting the crop to any other, certain location to some other.
Hmm.
And he has also received the notice, they have not, said that they have not received the notice. So he said that the deputy commissioner doesn't have the jurisdiction to issue such notice. He said the state committee, it is the notice for giving a proposal, which is not actually no order of the case.
So what order did they pass?
Their notice is not on the consideration unit. The order passed by your lordship, madam, that is not, because he has not challenged that order. So he has received, in the recent, he has not challenged the order. It was all-
What order did I? Now, here is a case where money has been taken, something I
No,
observed.
no, no.
Huh?
Money has been taken here. He has paid the fee.
A specific query made to the Learned Council as to whether similar actions have been resorted to in respect of other IMFL on and off license in the same locality, and as to whether the similar complaints have been raised by other persons in respect of functioning. The Council for the Fairly submits that he has no instructions with regards that. In the instance, it is apparent that the license was issued to the petitioner after making necessary inquiry, and once the license have been issued, the authorities can very well take action under the Excise Act if there is a violation to the license. The authorities have not taken any action in that regard. They have only verbally not permitted the petitioner to open up the shop, which cannot be mandated, and accordingly, the impugn actions of the respondent authority not permitting the area to open the area violates the IMA. This court interferes with such action of the respondent not permitting the area in respect of which a license has been issued and in respect of which the petitioners have been regularly paying the license fee. So it is directed the respondent shall permit to open and function area. It is clarified if the petitioner is found to have violated the conditions of the license or the provisions of the area claim shall be. Now, Here is a case where the petitioner was verbally asked not to open.
Yes, that is, but actually he received the notice, though in my reply, affidavit in the full term.
Hmm.
Yes, that yes, but he says that the other than that I mean, he has done not, this could have, he has not received the notice. And that is not a subject matter in the lead petition also.
Hmm.
Now my submission is that, the authorities may be procedure, since the notice has been issued, let him file a proposal that has been shipped, regarding shifting of the location by the. Because he has not, in view of his order by the, he has not complied with that location.
When did the notice issue?
No, it was notice of 3/11/2020.
But that was not the subject matter of the
Yes, that was-
petition.
yes, that was a suspension of bank also regarding the notice. Actually, because of the notice, he was not allowed to operate at that point of time.
No, was it in the notice mentioned? Where is that notice?
What is case 40,
Page
48, access
40. In view of the public protest in respect of AIUABA has to shift your proposed IMFS shop from the present line and submit a proposal accordingly.
There it was 100 meters, now because of the amendment, it has come to 75 meters.
And you are,
And the residents of this island, women.
Huh?
This is residential area, it's some island, it's not in a main.
where is this?
It was, it is,
Place is where?
well, in Albany town, that is called.
Hmm?
The island, it falls under the Bijapur. That is in the aspect of the. I am Chaudhary Port. From Albany town.
But his shop is at NT Road.
NT Road is actually not, NT Road is a hill area, man. It's a byland.
And you reside in the Berlin.
Byland.
Who are you?
We are the residents of that locality. Only this, how far?
All are residents of Prasanna Narayan Chaudhary Port.
Katabari, Bhaktapur, Mumbai town.
So it is next to your house.
How that pure. It's a residential area, that's why we are.
And nearby the vicinity, there is no other shop.
In that byland, there is for us. The main
No,
town-
no. Within 75 meters.
No. For subdivision.
I've asked them to file an affidavit. Where is it? Affidavit. There is no any IMFL on shops within the proximity of 75 meters of the IMFL. On shop of street. However, within 200 meters, radius 1. No. First and foremost, tell me, put the deputy commissioner, direct him, don't open the shop. That was the subject matter of the writ
Therefore,
petition.
company cannot direct.
Then what is wrong with the order?
Order, that order should not be barred from. In the notice, that, at least,
Issuing notice by?
when Deputy Commissioner for regarding 16 part. Because there was a, public objection.
Does the deputy commissioner have the power to do that?
So, he has not, he has only issued a notice to him to.
Does the deputy commissioner have the power to do that?
Existing power is issued by the commissioner.
The authority will have to do it. If any, I have already made it clear in my order, if there is a violation, they will take care.
Yes, our Deputy Commissioner simply has issued
That is useless. First of all, does the deputy commissioner has the power to do so? No. No, my order is very clear. See the last portion of that order. Consequently, it is directed the respondent shall permit the petitioner to open and function the petitioner's IMFL shop. It is clarified that if the petitioner is found to have violated the conditions of the license or the provisions of the Assam Excise Act and the rules framed therein under, the respondent shall be at liberty to take such action as is permissible under law. Then you say there is a violation, approach the commissioner, I give you the liberty. The instant review application has been filed by the review petitioners, seeking review of the order dated 6/1/2022, passed in WPC number 5217/2020. The case of the review petitioners is that the review petitioners are residing within 75 meters radius of the shop of the IMFL on shop of the petitioner. Mr. P. Kotoki, the learned counsel appearing on behalf of the review petitioner, submits that although this court have clarified that the petitioner, that the opposite party, the opposite party number 1, the petitioner in the writ petition, is found to have violated the conditions of his license or the provisions of the Assam Excise Act and the rules framed therein under, the respondent authority shall be at liberty to take such action as is permissible under law. The judgment sought to be reviewed may affect the rights of the review petitioners to approach the respondent authorities, respondent excise department. Taking into account the said aspect of the matter, this court is not inclined to review the order dated 6/1/2022, passed in WPC number 5217/2020. On the ground that there is no error apparent on the face of the record. On the ground that there are no grounds for exercising the review jurisdiction to the said order. Be it as it may, this court further clarifies that the said order dated 6/1/2022, passed in WPC number 5217/2020, shall not affect the rights of the review petitioner to approach the respondent authorities if deemed fit.
Sanction of the comment, it can be done. Sanction of the comment is available. Actually, Deputy Commissioner will have the previous sanction of
Now 25 to 27.
Oh. Yes, what is the height? Hmm?
Somebody for assessment.
I remember, you are a fisherman. You don't know. Huh? 10 feet high. And what is the area?
There is 6,478 feet.
So, so this can be done. And where are you going? And what is their rights? Their rights.
Nowhere. They are not, they are not, they are not being witnessed. But yes, together, they are not.
No, that is one. And in view of that provision, I have shown you GMC Act.
Annually,
It can't be for all times to come.
they are before that, they are not paying anything. They are before that, they have all their rights.
They're demolished for pending down, they're pending down because of the demolished. Now, my lord, that day I made some arguments, my lord, and everything is in this judgment, man. This is this judgment of this month court. How we came, why allotment is given to us? 244 on all the fabric, that.
Dusty and company is who?
And petitioner is in, petitioner number 200, consider market.
Yes, what is it?
But here it is. everything
I
is
take
explained.
him on to so and so the old Panjavada market was constructed in 1905 with wooden structures and tin roof. After independence, the management was vested with the then board. Thereafter, with the Guwahati Municipality, after enactment of the Guwahati Municipality, the market area was vested with the Guwahati Municipality, and there was the state was the first constituted after the fire in 1989, when there were more than 50 vendors coming from the fire. Have you made any payment?
Yes,
What?
initially we make payment and.
How much?
Whatever they fix, my names,
No, what payment?
rent,
No.
security guard,
For completion of the construction, what payment you have made?
or association. Because I have to come from the secretary, but
No. What amount you must have stated? Your right will only accrue then,
yes,
as per this order.
Yes.
Then,
because we are 310 numbers, 240 crores is already doing the business. The fish traders also doing business, but they have made an appeal that cannot run our business in that floor. That decision is taken here in township. That's all right. You may accommodate in your ground floor because toilets is not operating. And there is a tender will be called, that is a resolution.
now how many people are there? 13.
I want to contact my lord and I got allotment letters of 25 out of 55 and till that my lord, I have taken their exhibit that they are doing business or not. Only 13 come to my chambers my lord, I get them. I don't know, 30, 15 my lord, not mine. Genuine. And they have given exhibit that we are still hanging on. These are the
15. Mr. Bora, is there any space for them?
exhibits.
For those 15?
Is there, but I found it all of. But I have getting it another single. They all are demolished by her. I don't even take it that they'll be in the ground.
Huh?
They'll be in the ground.
They will be given in the ground floor only.
There is a reservation itself. After that, I am taking it now 45. There is a reservation.
In which street petition?
It's the number 183. All reservation on my. She said every town is less than developer. That's why they are not too much.
Affidavit filed on?
But actually, what's the extent? They all restriction.
Yes.
All 45. There is a second November 2007.
Yes.
How the vendors are there?
Page 45.
25. That is of November 2007. 17 they were from vendors.
Where is it?
Real number, the status of this.
Status, it is applies in this meeting for the accommodating the hassle. And I apprised the meeting that in the town vending meeting of Iman and approved to shift the mezzanine floor so and so. We informed that the mezzanine floor of the area there are some fish stalls and food stalls, etc., and the same will be shifted to the ground floor. He also informed that the meeting regarding the verdict of the High Court area allowing 3 months for units. After threadbare discussion, proposal for shifting of the access to the mezzanine floor has been approved and the commissioner was authorized to do the needful for shifting of the said buffers. So those people who are there, they will be accommodated out there in the ground floor.
They are all 29 7 as well as there is not a single of that particular. But if they demolish manufacturing because of they have to accommodate the access road, the demolish how can they are already. It's also so that the allotment they are paying right now.
Now, as I could see from the judgment of Justice Biswas, there is a resolution taken wherein it is mentioned on 9/8/2000. It is likely that some of the original tenants in the meantime may have expired. Some have discontinued business and some more might have transferred their tenancy to other illegally and others are doing their business in temporary market at Maskua to the great detriment of the city dwellers of the area. It is therefore resolved that only real tenants amongst the 5 victims be considered for allotment of rooms, stalls in the newly constructed marketplace. Now, if I give a direction to the JMC to consider only given to those people who are the actual tenants. Not those people who are legal representatives, no. Those people who were there at that point of time. Only because that has to be limited only to fees bend. They can't do anything else.
Madam, I have conducted some people's name. I have with all the affidavits given.
No, affidavit, this court is not going. And for Mr. Sharma's clients, you say there are 6,470 square feet.
5,478.
So in the mezzanine floor. And the height is 10 feet.
Not at all, Lordship. I had instructed them. We have taken some photographs of the place also. Lordship goes through it. There's hardly 73 inches,
They have
74
put it on instructions.
No, Lordship, kindly have a look. And the area. So from these pictures, Lordship,
Pictures, how can one get a?
you cannot be. I don't know, maybe. some information material, again, that you kindly see the group of the premises that we are being static. And it's not 6,000 square feet, madam. This is where they intend to booking 230 vendors. And my lord, if at any point of time, these vendors have at least go up to the customers, where this is place sufficient to accommodate everyone. Okay. And what happens, my lord? is-
Mr. Sharma, you have brought only from the beam. You have seen the height from the beam.
Yeah, that is maybe another 6 or 8 inches, that we must, my lord.
Beam
That is
can't be
what
6
we-
or 8 inches, Mr. This beam can't be 8 inches. It has to be more than a feet.
No, it is not.
How, what is the height of the building?
No, lordship, normally.
What is the height? No, what is the total height of how many stories?
4 stories. 4 stories.
Four
my
stories,
lord.
are you going to say that it will have a beam of only 6, 8
No,
inch?
no, lordship, what I'm on, my lord, lordship knows usually the mezzanine floors are not as high as the other floors. There's a shorter, it has a shorter roof cast on it.
Hmm.
And kindly see lordship before, this is the space, my lord, where they intend to accommodate 230 vendors. And lordship, at any point of time, supposing presuming they have customers, my
How
lord.
much was your square feet per vendor earlier? How much square feet were you function? Forget about the road. Forget about the road. How much square feet? You were in the footpath.
No, we were there, but.
You were there in the footpath.
Lordship, but
So understand how much square feet were you doing business? I have also not forgotten. I've seen it.
no, lordship, of course, has sent because it was so apparent.
Eh?
But my lord, the other issue is, supposing these vendors are accommodated there, any point of time, my lord, if there are customers there, can this space at any point of time accommodate 1,000, 1,500 people? Is it reasonably convenient? That is what the 2014 Act says. That is what the honorable.
2014 Act does not say anything to that effect.
No, it says, my lord, the schedule says,
The schedule will be only in respect of a plan being made. That it has nothing to do out here for relocation.
my lord, from these pictures, my lord, it is apparent that this is not a space where these 230 people can be accommodated for the purpose of carrying on their business. And my lord,
Then in that case, if are you saying with the authority from your petitioners that you don't want the mezzanine floor?
We want,
No, you can't say that.
no,
Do you want the mezzanine floor or not?
no, we want the convenient place because in the reg petition. we have-
Convenient place can be. They can give you a convenient place somewhere out there near Pamuhi. Huh? Near the Moniram Devan or Trade Center. Huh?
Look at,
Then let them get some customer, the people will move there. What do you say? That is the only way out, because you don't have, no, are you suggesting that some other buildings may be built?
no, no,
That the vending zone which has been done, this court should now say that the non-vending zone sit over the policy decision of the government.
Lordship, for the ends of justice, considering the plight of these persons, admittedly 230 vendors, my lord, and including their families. Lordship,
You want the families also to stay there.
no, no, not that, Lordship. My submission is, my lord, Lordship may give them time to find some alternate better.
Have they been able to find out anything for the last 5 years? They have not.
And at least,
That is the best place you can get nearby. Tell me, in that locality, is there anything?
nothing as such, Lordship, except that stretch of land, that stretch of road where we used to earlier.
So you want therefore this court should sit over their policy decision to do it. That is not in public interest.
My submission is if some temporary relief can be granted.
There is no temporary relief. This is a substantive writ petition to be finally disposed of.
So long they do not find an alternative proper location to shift the vendor.
The only place they will can give you is outside the vicinity of the GMC, which the state has to decide. The GMDA has to decide. They can decide, not them. Because that is outside. Does Pamuhi come under GMC? No. No, it is outside. That they can't do it. GMC, the jurisdiction is limited. If you have made the GMDA, they could have shifted you to Palasbari. You have nearby land near the new international airport. They can have good business there. GMD it is. It is under the GMD. And we appear for the GMD also.
I'm basically looking it up to my lordship because I've placed everything.
Mr. Sharma, there can be done nothing else if you want it here. If you have any difficulty out there, you can very well approach thereupon the authorities, but not, this court is not going to do anything out here any further. You can approach, the authorities may consider, but you have to also see the GMC. Does GMC have any place? On last occasion, I have given you the opportunity out here, not last while. Show me a place where you can be accommodated. Show me. Unless you want that a newly constructed, these things which are being made to beautify the riverfront, you want to vend out there, it's a different respect.
That is not even our prayer in
No, obviously, there because the repetition was filed there. But does it make any sense to keep this repetition pending any further? You have got the mezzanine floor. If you approach you have to approach the authorities concerned for getting allotment out there for specific to your area. And after that, if it does not fit, you say that it does not fit, he says that it is going to fit. This court cannot decide unless I go there and find it out with a tape measure and all. So unless that is not there, nothing could be done. So if it does not fit, then you submit your representation, they will consider that that is the only thing this court can do. Isn't it, Mr. Bora? Anything else, I can't do it. I gave you an opportunity to give me a space where there's no space within the GMC area now.
That again, Mr. Bora is harping on it. What the Honorable Division Bench has said, that it has to be a proper vending zone. That is what I am on. And how, Lordship, apparently that space was allotted to someone, knowing fully well that all these vendors they said in seat there.
Why are you not doing something with that parkings? These parkings which you are having, these have become useless. Nobody parks out there in the vehicles. Does anybody parks out there in the MMC area? No. Does anybody parks out there in the this Shraddhanjali or Shraddhanjali Kanun area? Nobody. Nobody parks in those places. Has anybody, have you seen? Have you parked at any point of time in the lift?
Parking is there in the Palpatara area.
No, not that. That one near MMC.
There is more parking up there. I have parked it. There.
No, you have parked it down. Have you parked it up there with using the lift? Nobody is doing. Nobody uses the lift except out there at the city center. Nobody uses anywhere. And you have made huge things. So you can't do, these are spaces which are available. Why don't you think about something to that effect? If those parkings are not happening, because that is a parking when the parking is actually not happening. So many notices have been issued. On practical side, if I say, in this particular area at the Sadhan, this Kanu, so many notices. The police have tried and got fed up with these people asking them to kindly go and park out there. Nobody does that. And the entire area is lying idle.
I have never parked there.
No, it is lying idle. Even maximum cars goes at that point is the morning, 6 o'clock in the morning. Nobody is there parking. All are parked on in the roads. I hope now with the flyover coming, they may park out there. It's a different thing. Otherwise, it is getting jumped. That this place also, same thing. Unless the government uses it for some other beautification purpose, it's a different aspect of the matter. But this place is lying unnecessarily.
I have parked the petrol, but on other areas, I have parked in the ground. Now,
Nobody has parked on top. And the entire 3-story or 4-story they made has been made useless. Anyway, the best of the thing which can happen is for you go there, they will give you the allotment because they say that they are 6,470 and they can accommodate all of you. The height is 10 feet. Go there, they will give it because you have to take it. Don't leave out that. Tomorrow you may not get. Tomorrow you may very well ask them and make it more air conditioned or what. Tomorrow is the fish market may be or any other markets may be an air conditioned. And then for you go and place it out there. They will take a consideration only as regards the original tenants. And they will consider and give you in the ground floor if it comes. Disposed. What? That is the decision of the mayor also. That only to the original tenants. Yes. Only original fish vendors. Disposed.
In that case, Liberty remains to be a district.
Not to come here.
No, first they go there,
No.
go there,
First take
first take the possession,
then not satisfied, submit. The liberty ends there. Thereafter, I am not saying anything. If it doesn't ready. Any urgent matters? No hearing.